Yes.
Okay, I'm praying for listing of a case on Wednesday, Lordship. We have filed on 15/12, Lordship, before vacation.
Find out whether it is in defect or not. If
Earlier
there is
it was
nothing,
defected, Lordship, but it was rectified later on.
when did you rectify?
Lordship, after vacation, Lordship, we have to. Monday, on Wednesday, Lordship.
Item number 38, my lord, speaks for hearing, my lord. In fact, Lordship had heard the matter and asked me to my lord, submit
That's
written argument. My lord. I'll submit it by 2, my lord, today.
By 2?
Yes, my lord. Definitely.
What about you? At 2 Lord.
May I please, Your Lordship? My lord, I beg to mention for listing a matter. My lord, it has been filed on 19/12, my lord. No defective is there, I think.
There is no defect in
No
it.
defect.
Have you checked?
No, not checked, my lord. Not checked, my lord.
Find out. Otherwise, it would have been listed by now. If there is any defective query, then you make a mention. Initially, you just go and find out, make a mention at 2 o'clock, doesn't matter.
Well,
We have granted you permission. First, you find out whether it is defective or not.
Obliged.
Yes.
May I please, Lordship? My Lord, I wish to mention item number 19, my Lord. But I have personal difficulties today, my Lord. I have to leave the court, my Lord.
Prepare people. After anything. Yes.
May I please, Your Lordship? Lordship, I beg to mention a matter for listing, Lordship, read petition. Lordship, the matter is against the order of the CAT, Lordship, we challenge it. Service is complete, Lordship. And on the last date, it was not reached, Lordship. There is some urgency. Can it come after vacation, Lordship, any day?
19th.
Much obliged, Lordship.
May your lordship, I'm on behalf of M. Hussain from Delhi 16 and 17 number item. He has some personal problem, so matter may be adjourned.
There are other counsel. Why only M. Hussain? Mr. Singh is there, Mr. Rahman is there. What's your good name?
Abdul Warid, Warid. 16 and 17.
Yes.
May I please, lordship, I beg to mention item number 8, lordship. Lordship, maybe kindly we take it at 2 p.m. lordship. Some other matter lordship will clash there. I like to do. Obliged, lordship.
Lordship, this is a contested matter where the father's name appears in the 1971 voter list, which is in page 19, Your Lordship. Riazuddin is his name of his father. Whereas in 1966, the name of his grandfather appeared, whose name is Araz Ali, but it appeared as Abar, whereas the great grandfather name is correctly mentioned as Nadu. And the name of the petitioner, along with his father and brother, appeared in the voter list of 1985, which is at page 21. Riazuddin, Nurul Haq, Abdul Haq, and Gole Khatun is the mother of the petitioner, who also appeared to adduce her evidence. And her evidence is at page 42, Gole Khatun. Gabura of both the places, present place and his birthplace, also appeared and adduced their evidences, which is at page 41 and 43, where the Gambura of his birthplace is very clearly mentioned about their shifting of the places in favor of the petitioner. Gambura, Gangura evidence 43 or 41.
Where is your link document?
Lordship, at page 21. My father name Riazuddin, along with my name Nurul Haq, my mother name Gole Khatun, and Abdul Haq, my brother.
Prior to this, the only voter list of your father.
Prior to 1985 is 1971. Lordship can find in page 19. 20 is the vernacular. Riazuddin, son of Araz Ali, my grandfather.
After 71, what happened?
After 71, 85, the 93
In
voter
between,
list.
in between,
In between, this could not be provided. He has provided the link of 1971, 85, then 1993, 2004, 17 as a continuation process. And the Gangura of the birthplace as well as the present place also deposed their evidences. Lordship can find at page 43, the Gangura of his birthplace has clearly mentioned about his family, hereabouts.
in your written statement, you have stated that up to 1993, you stayed with your family at village number 2, Kochua.
Yes, sir.
So there has to be a voter list after 1970 till 1993.
After till 1993, it appears as a Kochua, Your Worship.
Hmm.
Then,
If you are living at Kochua
Yes,
till
sir.
1993,
yes, Lord.
then how come your name figured in the voter list of 1985 at Kochua? You said 1993,
Yes,
right?
Lord. Yes, Lord.
Prior to that,
The name was not being transferred from the place, Your Lord. He appeared there and casted his vote. For his work purpose, he came to the different place.
you have not stated that your father shifted from village Sankola to village Kochua in your written statement.
That was not mentioned, Your Lordship.
And your voter list of 1971 relates to one Muhammad Riazuddin relates to Sankola village.
Yes, Lordship. Prior to that, before his birth, where his parents belong, he could not adduce that in his written statement, Lordship. But in the Gambura statement, here it has been clearly
As
stated.
you are fully aware, if there is no mention in the written statement, it cannot be accepted in any other statement.
Yes, Lordship. But
So-
due to the fault of a lawyer,
Mention of
Lordship,
fault is not there. Whatever the procedure will say to his counsel, it will be written. Because it is the personal knowledge of the procedure that what the apex court has laid down in its law, right?
yes, Lord.
So don't blame anyone. Whatever is in the knowledge of the procedure, that has to be, that is the reason why the evidence of the procedure is more important
Yes, Lord.
with regard to the Foreigners Act. Entirely in the knowledge of the procedure
Yes,
and nobody else.
but the procedure is a
So,
young
The procedure
educated.
could not state where his father was prior to 1985.
But that was stated by the mother who adduces her evidence in OPW.
Whether in the 1971 voter list, mother of the petty procedure reflected in a voter list.
Mother in 1985, her name appeared.
We are asking whether the name of the proceedee's mother reflected in the voter list of 1971 along with his father.
No, Lordship, in the
Then
1970.
Any statement made by the proceedee's protected mother will have any effect when it is, there is no mention in the written statement of the proceedee. What? Anybody can appear and can say in evidence that has to be accepted. So
But
as the law,
Gole
if
Khatun,
there is no mention in the affidavit, in the written statement,
yes, sir.
it has to be accepted if there is some statement made by a particular witness on behalf of the proceeding. Whether it needs to be accepted in law.
But in the page 42, Lordship, Gole Khatun, the mother of the petitioner, stated that she has casted her vote in 1971.
Where you
But-
have mentioned the name of your mother in the written statement? Where you have mentioned the name of your mother in the written statement? Which paragraph, please?
Mother name was not reflected in the
Then-
documents.
We don't know who is your mother.
But documents was submitted.
That
during
doesn't
the-
matter. Whatever document you might have. Where in the written statement, you have not even, many of such cases we have found. That the procedure doesn't give the name of their mother. Why? We don't know. But here is also a case, the procedure in his written statement did not state the name of his mother. So do you want that the tribunal or the court to believe that statement of the proceeding protected mother?
So, Lordship, the real mother, Lordship, if
We
required,
don't know what is real or artificial.
if required, she would go for the.
Nothing else. We cannot allow at this stage to amend the written statement. We are here in certiorari, not in any other read. Anything else?
The Gambura statement is there, Lordship,
Gaura, which village?
of his Kausua village, ghetto, where he was born.
How the petitioner, how their Gaura will know that father of the petitioner resided at village Sanpula?
Lordship, his the Gambura's father was also a Gambura, and from that he has, from knowledge, he has stated
Only from knowledge, not from record.
at page 43, Your Lordship.
Those kind of evidence will not come to your aid. So.
That's your grandfather's name,
Araj,
Araj,
Araj Ali.
but in 66 total is no Araj
Ambar
Ali.
Ali.
Yes, Lordship. For that, an affidavit was filed for the one and the
It
same
is
person.
only Arbar Ali.
Abar Ali. It was wrongly stated there. But in the name of Araj Ali, there was sale deed was done in the year 1950 and 1955 and 1999, which was could be traced in the LCR
If there is a
also
sale deed, that will be amount to prove the citizenship.
for his linkage or not.
What happened to Araj Ali or Arbaz Ali after 1966?
He expired, Your Lordship.
Which year?
In between, Your Lordship, 1966 to 71, he
If
expired.
your father was 45 years in 1971, why in the year 1966 name of your projected father did not reflect with his parents? His name should have been there in the voter list of 1966.
Yes, Lordship. But his name was not reflected for some reason, Your Lordship.
As per section 76 of the Evidence Act, whether the voter list of 1971 or 1966 can be considered as a piece of evidence. Tell us.
1966, 71.
Read section 76 of the Evidence Act and tell us whether this can be considered as a valid piece of evidence. Do you have the Evidence Act with you? Yes, no problem. Read section 76 aloud.
Every public officer having the custody of a public document which any person has a right to inspect shall give that person on demand a copy of it on payment of the legal fees therefore, together with a certificate written at the foot of such copy that it is a true copy of such document or part thereof, as the case may be, and such certificate shall be dated and subscribed by such officer with his name and his official title, and shall be sealed whenever such officer is authorized by law to make use of seal, and such copies so certified shall be called certified copies.
So it has to be certified to be true copy, first of all.
Yes.
Right? And secondly, there should be a date
Yes,
by the concerned officer.
Yeah.
His name,
yes,
person authorized, his name, signature and seal. Please come to page number 19, 18. Is there any date of the person concerned who is authorized to issue that certified copy? Is there any name of the concerned officer who was authorized to issue that certified copy?
AC Bhuya is there, also DC Commissioner, Election Officer, Nagaon seal is there.
Yes, we cannot twist and turn the act. It is very specific, but it should be there.
Copied by.
First of all, date, the name of the authorized officer with his signature, seal. Right? Is it there? Date is there?
Date is the only the
Everybody
copied,
compared.
copied and compared is there. So this is,
Come to page number 20.
but these are the documents issued by the office.
You will not know. But there are certified copies. We have shown to the council for the procedure. With full name, seal, signature and date.
Lordship may kindly inquire the same if it is
We are
there,
not going to inquire, it is your case.
and we may be allowed to bring a new certified copy, your Lordship.
It is your case.
We will file an additional affidavit in this case.
I
with
will
the-
help you. When you will not able to prove your linkage.
These are the certified copies issued
Is
by
there
the
any
office.
mention that your grandparents or your father have shifted from village Sankula? In the
Yeah.
written statement, when you inquired, you said no.
Yeah.
Then. How will you indicate the Arbaj or Abar of village Sankula with Rayazuddin of Araz, son of Araz Ali of village Sankula, and that of Riyaz Uddin of Araz Ali of village Kosua? How will you link when there is no mention about it in the written statement?
In the opinion of Lordship.
Hmm.
At page 49, the Garnet Tribunal has clearly mentioned that after perusal of the documents produced by the proceedee, it appears to me that the proceedee Nurul Haq is the son of Riyazuddin, who is the resident of village Kochua.
Hmm.
Where there is no doubt that he is the father, but only
Then. From the voter list of 1985,
yes,
Nurul Haq, son of Riyazuddin, is possible. But it is of 1985. You have to show your father existed prior to 1971.
Lordship, in this case, I may be allowed some time to prepare your Lordship, and Mr. M.A. Lusper is the senior counsel who is in this case. I'm appearing on behalf of him. Let him appear, Lordship. In the meantime, I will go through the record also.
11.
Lordship.
11.
Yeah. Obliged.
Lordship, my senior is in Lakes, Lordship. We have received our instruction, Lordship. Matter may be taken after some time.
You are appearing for whom?
Mrs. A. Gayan, Lordship.
We'll have it after some time.
Hello.
Yes.
Ex parte case, my lord. The petitioner has been detained since 31st of October. On the last
Lordship
petition,
had sought for the records. Lordship, we have the records.
Kindly give it to us.
Yes, Lordship.
Seven, seven, eight,
Take a seat.
My lord.
Where is the illegality? The order?
My lord. Is the petitioner, she engaged a lawyer and subsequently she couldn't pay her fees. And that's how she was declared as a foreigner, my lord.
belongs to an extremely poor family.
Read this record and tell us your submission is correct or not. Read the order sheet. Then the Haziras filed daily.
Yes, my lord. So this is what instruction I got, that they were supposed to file written statement, but because she couldn't pay, my lord, now what will happen, my lord, if she is in detention, my lord? I completely understand. I am not disputing anything, my lord.
Say, so receive the notice.
My lord, correct.
It is easy to blame a lawyer. Now, the notice was received by her.
She received the notice, my lord.
On 21st of June 2019.
My lord.
She appeared before the tribunal
Lord,
on 29th of June.
my lord.
Tribunal granted time till 2nd of July.
My lord.
On 29th of June, because of unavailable circumstances, she could not appear before the tribunal. That's the prayer of the council. Date was fixed on 27th of July.
Hello.
22nd of July. And on 22nd of July, the proceeding did not appear. And the Hazira was filed saying that the proceeding is ready to appear, but due to non-collection of proper document,
My lord.
she could not appear on that day. Next, that was fixed on 14th of August. On 14th of August, on 14th of August, proceeding did not appear. But on her behalf, Hazira was filed by the council that because of unavoidable circumstances, the proceeding could not appear.
My lord.
So another day. It was considered. The next date was 4th of September. On 4th of September, similar prayer, unavoidable circumstances of the proceeding. It was fixed on 25th of September. 25th of September again, unavoidable circumstances. On 25th of September, matter was fixed on 21st of October. On that day, Hazira was filed, proceeding did not, she remained absent. Hazira was filed saying that proceeding was about to appear, but due to unavoidable circumstances. Thereafter, the matter was fixed on 21st of October. So on 21st of October, similar prayer, unavoidable circumstances about to appear. And next date was 18th of November. On 18th of November, the proceeding remained absent and the Hazira was filed that the bailer sustained injury in a motor accident. So, and hospitalized. So a next date can be fixed. As such, the tribunal fixed 23rd of December on 18/11/2019, directing the petitioner to appear, observing that if she fails to appear, the tribunal will pass the required and necessary order and answer the reference. On 23rd of December, nobody appeared. The petitioner proceeded remained absent. And ultimately, the reference was ordered. The appointment was given. So tell us where is the illegal?
My lord,
Above that, the proceeding was fully aware, a proceeding was going on against her in the tribunal. And after that order of 23rd of December 2019, she remained silent. And only after her detention, she obtained the certified copy of the said order on 2nd of November 2023 and filed this writ petition on 19th of December 2023. So from 2019, when the tribunal passed the order,
for 4 years it was not challenged. my lord.
she was fully aware. Record is before you, you
My
have
lord.
seen it. So was the illegality,
My lord, may I say
nothing
this?
else.
May I,
So
may I,
was the illegality.
may I humbly submit this, my lord? My lord, the tribunal was correct. Tribunal was right, my lord.
It was correct and correct.
My lord, now what will happen? This person, concerned person is a 63-year-old woman.
We do not know anything.
My lord,
We want to know whether the order of the tribunal is bad. If it is bad, in which circumstances?
now, my lord, if the case is not remanded, she will be in detention.
We are
and-
asking you something. Show us how the order of the tribunal is bad in law.
My lord, she belongs to an extremely poor
We are asking
family.
you that.
Now, if the order is not,
If she is poor, she could have approached directly before the tribunal. She could have asked for any legal aid. She could have said, I do not have any lawyer. I do not have any amount to pay any fees to lawyer. The tribunal have taken.
probably, my lord, she was not even handling the
We do
case. A
not-
family member was doing it on her behalf. 63-year-old indigent
Any
woman, my
else?
lord.
Show us if there is any illegality in the order and the rest you know.
My lord,
Is there any illegality in
I'm
the
just
order?
trying to explain the repercussion, my lord. What will
We do
happen?
not know. We are here in certiorari. Tell us where is the order is bad in law. And if it is, then where?
My lord, the tribunal had no other option, my lord. But my lord, now the repercussion will be very harsh, my lord. She will be in detention, my lord.
Mr. AWM, counsel appearing for the petitioner.
My lord, may I say this, my lord? I humbly request before your lordship, my fervent request, my lord. She is a
Show us where is our power.
63-year-old woman, my lord.
Show us where is our power in exercising the certiorari to pass that order. Show us.
My lord, this is the
In
court of
exercise of the
justice, my
power
lord.
under Article 226,
If the-
particularly certiorari, Mr. Ravan, kindly show us that power that we can exercise.
I'm only going to the repercussion, my lord. If the case is not
We are not
remanded,
here for any other read, as
she
you
will
know.
have, she will suffer from lot of injustice, my
Mr.
lord.
Ravan, we are asking you.
My
Can you
lord,
answer? If you
because
are
of her
to
poverty,
show-
my lord, she could
Show
not,
us any such order of the Honorable Apex Court
my lord.
that the read court, while exercising certiorari, can do that.
But in the next hearing, I will submit.
Where is question of next hearing? It's over. Relevant order will follow. Next.
We believe it. Sure. I thought we had-
Gitangeli Data Collector. Gitangeli Data Collector. Gitangeli.
Just-
Gitangeli.
Lordship, I just have a small submission. The
Yes,
records are records in item 4. The FT records are before this court, so Lordship would kindly observe that in the order.
Of course.
We have submitted them, Lordship, so we'll need to send it back.
Yes,
My lord, I have received the instruction that is that matter relates to the Ministry of My lord, I have received instruction, my lord, that matter relates to Ministry of External Affairs, my lord. Not the Ministry of Home Affairs, my lord. They have already communicated, I have already communicated to them also, my lord. Some time may be granted, my lord. Which are the? Oh, sorry. Maybe Ministry naman ang direction dito, External Affairs. My lord, they have already communicated me, my lord, External Affairs, my lord. I have already communicated to the Passport Authority also. Sometime may be given, my lord. They are getting ready the document, my lord.
Ms. Gahan, kindly tell us one thing.
Yes, my lord.
Whether at the time of issuance of a passport or renewal of a passport,
Yes, my lord.
ground report is obtained, right?
Yes,
It has to be given by whom?
my lord. The passport, renewal of passport, my lord. That verification has to be given by the police authority, my lord. In renewal of, I'm not aware, my lord, whether in verification, in renewal, there's any role of the police or not, my lord. But my lord, within 2-3 days, my lord, I'll get the every instruction, my lord, from the passport authority also, my lord.
Mr. Sharma. Petitioner herein was declared as a foreigner by the tribunal
Yes, boss.
on 8th of December 2016. The claim of the petitioner is that his passport was renewed in the year 2021.
Yes.
We want to know from the DGP how this passport was renewed
Yes, boss.
in the year 2021 when the petitioner was declared to be a foreigner by the tribunal concerned in December 2016. What's going on? Now the Home Department of the country is now pushing the blame on the external affairs. And they want 2 months' time.
But not too much, my lord. I have
Look
already.
at the letter.
Yes, ma'am, they are written, but I have already communicated to the external affair, my lord. Within a short period, they will.
We want by this Friday, the
Yes,
report of the DGP. Nothing else. We don't know what kind of things is happening. In the previous case, you have seen the proceeding has approached this court after 4 years.
Lordship,
against the order of the tribunal only when she was detained in custody. Here is another case.
Lordship fixed on
Why?
18. I'll.
Maybe on Friday. We want that report on by Friday.
No, 11, no, Friday, 12.
The report is so clear, Mr. Sharma, that the tribunal on the same day forwarded the copy of the tribunal's order to the Superintendent of Police Border Ojai. On the
Yes.
same day,
Lordship,
the record reveals
yes, Lordship.
that is in the year 2016.
12. 12, I'll take instruction. From the,
We have seen many records like that.
Lordship.
DGP has to act. And this, in the previous case, the proceeding was detained in custody because of the interference of the order passed by the court. It was found in numbers of cases when the tribunals passed the orders declaring or appointing somebody to be foreigner.
Lordship.
The police department kept low. Nothing was done.
Yes, Lordship. 12, I'll.
An order was, the report was submitted before the court, in which cases the orders been passed, appointing or declaring some proceedings to be a foreigner and what actions to be taken. It was found none. Then immediately there was sudden rise and many were detained into custody. The similar case in the previous case. Here is also a case, the proceedings before us, saying that his passport has been renewed in the year 2021. Though he was declared to be a foreigner in December 2016.
Lordship, yes, Lordship. On 12, I'll take.
By Friday,
Madam, direction also may be given to the external level to
Of
place.
course.
Madam. Yes, madam.
by Friday.
Yes,
Madam,
Lordship.
Friday. Madam, other CDC will appear. I may not be available, madam. Other CDC will appear, madam. I'll place that all documents, madam. Madam, madam.
তোমালোকৰ পৰা তো বস্তু পাতি লাগে
Or MSRDB Learned Council appearing for the petition.
মানে
When the petitioner appeared before the Superintendent of Police Board,
Your Lordship. 28, 12, Lordship.
are you sure?
Yes, Lordship. This is the copy, Lordship.
Give it to her.
পরিমাণ এসা নেকি আইটেম 5
No, no, no. Attempt 3. Ibrahim Ali.
কপি এটা এক্সট্রা কপি এটা দিব লাগিব দিয়া
কোনটো?
রিপিটিশনার আমার লগত নাই itu কেনেকৈ ইস্যু কৰিছে
হয়তো কেনেকে তোমাক পঠাইছো।
এই তো প্ল্যান নাই আমার হাতে।
ঠিক আছে।
19 না নহয় জানো
হুম।
19 না
তোমাকে কিন্তু নতুন নেই।
Mr. Z. Sharma, Standing Council Home Department. Are David for one. Petition. MSA Learned Service reported. Also heard Mr. Z. Sharma, Standing Council Home Department. Assam. For the response number 2 and 4. As well as Mr. P. Sharma, additional senior government. Assam. For the response number 2. Yeah, it's Standing Council. Elected Council. The response number 7. The Foreigners Tribunal, Ojai, Sankatep Nagar. Impugned order dated 08/12/2016. In case number FT/H/2471/2012. Declaring the petitioner to be a foreigner under the Foreigners Act 1946, who had illegally entered into territory of India within Assam on or after 25 1961, comma, according to us, is not a necessary party for proper adjudication of this writ petition. According, the name of respondent number 7 is struck off from it outside. Earlier, on 13/12/2023, we passed an order directing the Home Department in the Union of India to apprise the court. Directing such on passing order, fixing the matter today, directing the Home Department in the Union of India, respondent number 1, to apprise the court as to how the passport of the petitioner was renewed by the central government in the year 2021, though he was declared to be a foreigner by the Foreigners Tribunal on 08/12/2026 in case number FT/H/2471/2012, where a copy of the said order dated 08/12/2016 was also forwarded to the Superintendent of Police Border, Hojai, by the said tribunal. এই আগতে by a foreigners tribunal লিখতে, by foreigners tribunal number, foreigners tribunal Hojai Champa. On the same day, i.e. on 08/12/2016. Today, Ms. Gayan Lanet CGC placed copy of the communications dated 04/01/2024 of the Ministry of Home Affairs Foreigners Division, as well, Foreigners Division, informing that the subject matter regarding renewal of passport, P capital, pertains to Passport Division, Ministry of External Affairs, and the requisite information sought for by the court may be available only with the said ministry. And as such, prayed for some time. List on 19/01/2024.
Yeah.
And on the said date, Ms. Kayan Lanet CGC shall place the up-to-date report regarding the issuance of renewal of passport of the petitioner in the year 2021 in spite of declaring him to be a foreigner by the Foreigners Tribunal on 08/12/2016. Next. On the said date, the Director General of Police on the said date, the Home Department of the state shall submit a report properly inquired by the Director General of Police Assam on the said date. The state government Home Department, that's one number 3. Submit a report police as to how the petitioner's passport could be renewed in the year 2021, though he was declared opined to be a foreigner by the Foreigners Tribunal. Concerned Foreigners Tribunal noted above on 08/12/2016. And consequential action taken report in that regard. It is submitted by MS Devi, counsel appearing for the petitioner, that pursuant to the order dated 13/12/2023, the petitioner appeared before the Superintendent of Police Border on 28/12/2023, and accordingly went on bail. Copy of this order, as well as the order dated 13/12/2023, be furnished to MSA Gayan, Lanet CGC, Mr. Z. Sharma, Standing Counsel for Foreigners Tribunal, as well as Mr. P. Sharma, Additional Senior Government Assam, for their required use and necessary for their necessary action and onward communication to the Home Department of the state, as well as the Director General of Police Assam, for their needful. Copy of the communication dated 04/12/2024 of the Ministry of Home Affairs, Foreigners Division, placed before the court today by Ms. Kayan Lanet CGC, be kept as a part of the record. Let's record.
Copy of the draft plan of a petition of the people.
Master.
I'm seeking an accommodation for the DMA lot.
Lordship, the records are here, Lordship had asked us to produce
You
the
have the
record.
records?
Yes, Lordship, we have it.
that is. We need to record this, no? What I did to see that.
Yes, Lordship. I have gone through it, Lordship. Lordship, though sufficient.
My lord.
Yes, Lordship. Lordship, in between, yes. Yes, Lordship. Yes. Though documents were submitted, Lordship, ample opportunity was granted, but the proceeding never came to the court on some pretext or the other. Lordship, I would just like to rely on this matter, Lordship. Exactly same, Justice Bhuya had passed an order, Lordship. Lordship, 2021-10-2021, Lordship. She is absent without steps. She never appeared. Oh, yes, Lordship. Yes. But again, an opportunity was granted fixing the date for written evidence in chief on affidavit. And 29-10-2021 for written evidence in chief on affidavit or as DW1 with cross examination. Next is on 29-10-2021. She remained absent without step, heard learned assistant government pleader for the first party. Hence, the ex parte order shall be passed on the basis of the report of the inquiry officer. Order is delivered and prepared. Lordship. Yes. Cross examination. Yes, Lordship. For necessary orders, yes. Yes. Lordship, the tribunal is also bound by the law, Lordship. The order says, FT order 38 of the tribunal 64 says, Lordship, the FT shall give the proceedee 10 days time to give reply to the show cause notice and further 10 days time to produce evidence in support of his or her case. Sufficient ample time has been granted all through, Lordship. In one of the matters, Lordship, Justice Bhuya had observed, may I just read it, Lordship? Lordship, this was also an ex parte order, Lordship, which was before this High Court. I'm reading from paragraph here. I have an extra copy if Lordship would like to go through it. Three, it's not numbered, but Lordship will come to paragraph 3, Lordship. As it transpires, for on the date the order is passed, as it transpires from the materials available on record, the petitioner had responded to the notice issued by the Foreigners Tribunal, Dorong, Mongolian, prayed for time to file written statement, which was granted. On 3/2/2018 and 12/2/2018, the petitioner was absent. The petitioner was absent without any steps. Lordship, in this matter also on the first 2 dates, when the matter was fixed, the petitioner was absent without any steps. Thereafter, on 22/2/2018, 19/3/2018, 31/3/2018, 13/4/2018, 11/5/2018, 19/5/2018, and 11/6/2018, the petitioner was present and prayed for time to file written statement. Eventually, on 25/6/2018, the petitioner filed written statement with certain documents, and the next date was fixed on 13/7/2018 for orders. On 13/7/2018 and 26/7/2018, the petitioner was again absent with steps praying for time through engaged counsel. Thereafter, on the next 6 dates, the petitioner remained absent without any steps. The petitioner made no effort to prove her case, and even on the date of delivery of opinion, the petitioner remained absent without any steps. In such a situation, an adverse view was taken by the tribunal, and the impugned order, ex parte order dated so and so, was rendered. Having regard to the facts as above, we find that sufficient opportunities had been granted to the petitioner to establish her claim as not being a foreigner, or to refute the allegation that she had illegally entered into the territory of India after 25/3/71. In this context, we may observe that although the procedure of identification and for declaration an individual to be a foreign national cannot be relegated to a mechanical exercise, and that fair and reasonable opportunity must be granted to a proceedee to establish claim that she is a citizen of India. However, such grant of opportunity cannot be enlarged to an endless exercise. A person who is not diligent and or is unmindful to take steps to safeguard her interest, she does so at his own risk and peril. In the instant case, several opportunities were granted to the petitioner to establish her claim, which she utterly failed to do so. In this context, we may observe that in a proceeding under the Foreigners Act 1946 and the Foreigners Tribunals Order 64, the primary issue for determination is whether the proceedee is a foreigner or not. The relevant fact being specially within the knowledge of the proceedee, and as such, the burden of proving citizenship absolutely rests upon the proceedee, notwithstanding anything contained in the Indian Evidence Act 1872. This is mandated under Section 9 of the aforesaid Act 1946. The said position would not change even in an ex parte proceeding before the tribunal, as the burden never shifts but continues to be upon the proceedee. In a situation where no evidence is adduced or the burden is not discharged, the only option left to the tribunal would be to declare the proceedee to be a foreigner based on the grounds of reference upon which appropriate proceeding was initiated, where notice was issued and duly served upon the proceedee. In the instant case, the petitioner utterly neglected to participate, contest in the proceedings. Lordship, I'm relying on this, and it fairly covers the complete case of the petitioner here, Lordship. Yes, Lordship. Yes. Yes, Lordship. Yes, yes, Lordship, yes. Yes, Lordship. Yes. Final order. Yes, Lordship. Yes. There are many other cases also where written statement has been filed, but evidence has not been adduced, Lordship, and proceeding remains absent on many dates without taking steps. It- Yes, Lordship. She was arrested, Lordship. She's also in detention. Lordship, my point which I want to make is that these proceedings cannot be endless proceedings. They have to come to a logical conclusion. They're not appearing on certain dates, not taking steps, not being mindful of what they actually want to do, Lordship. Lordship, these records would be retained by the court. Yes, Lord.
With your lordship permission, can I submit one line on item 4, Mila?
Lordship, item,
My lord, your lordship is correct, my lord. Your lordship is correct. I'm not. But she's in detention, that's why I wanted, your lordship is correct, my lord.
Lordship, item 4, Lordship, I just want to submit this citation for item 4. Thursday, no? Your matter is fixed for Thursday. Thursday would be 11th.
Keep job like.
Lordship, there is a mistake on our part. Lordship, we had the respondent filed the OA claiming benefit on the basis of the judgment passed in the criminal code. That is not on record. Let me bring that on record through an affidavit. Lordship, give me 1 week time, Lordship. That will be necessary, Lordship. Because he claimed benefit because he has been acquitted by the criminal code. That judgment may be kept in the Lordship. That's I am relying on all this. Bringing into records. The trial court judgment by which he has acquitted. Oblige, Lord.
May I please your lordship, my lord, this is a contested matter and in this case petitioner herself has adduced evidence. She has exhibited the voters list of her father of 1966, 70 and in one judgment of her mother, wherein mother was declared as not a foreigner. And her elder sister and mother name appeared together in the voters list of 1996 lordship, or 1995 lordship. And she also has adduced evidence before the learned tribunal. And her linkage document was also there. Gambura also has adduced evidence. Her mother's opinion is also at page 85. Lordship. Yes.
Wow, that knows you. Well, counter statement to one. Counter statement to first. And when I go to case that. The people in that. Counter. Opinion.
RMS Depot's counsel appearing for the petitioner. RMS A Verma standing counsel for Department Assam for the response number 2, 6, 7. Also heard Mr. A.I. Ali standing counsel election commission of India for the response number 3, and Mr. Sharma, additionally senior woman in Assam for the response number 5. On being referred by the Deputy Commissioner of Police, Kamrup Metro. By F.T. Case number 503 of 2017, dated 14/07/2017. The learned member Fairness Tribunal Court, Kamrup Metro, Assam. Guwahati. In F.T. case number F.T. within bracket K within bracket M bracket 2, that's 4. 1205/2017 by the impugned opinion dated 30/10/2023. Opined before that. After hearing the parties including the petitioner and considering the materials adduced by her by impugned opinion dated such and such, declared her to be a foreigner under the Foreigners Act 1946, who had illegally entered into territory of India some honor after 25/03/1971. This satisfied this opinion dated 30/10/2023. Noted above. The petitioner has filed his writ petition on 05/01/2024. So notice enabled by 8. That's still right. Phone number 1. Union media remain unprepared. Honor before 24th. January. Deputy Commissioner of Police, Kamrup Metro. Ms. Ghosh, why you have made Superintendent of Police Border Kamrup a party here instead of Deputy Commissioner of Police Kamrup?
Yes, Lordship, this is my mistake, Lordship. Yeah, DCP, I should have,
Cut and paste is not good.
I apologize for that, Lordship.
Kamrup Metro. Honor before 20. Rest will follow. All for the records. FT case number FTKM. Industry page number 34. Okay. Decided on 30/10/2023. As well as the record of IMDT case number 1618 within bracket Z/1990 from the dispose of on 05/08/1993. State Arsi. Joyna Bormon, Joyna. From the office of the Furnace Tribunal, Valpara. Within bracket, I am getting Valpara. Registration list, the rest will follow. Registration list is matter. For admission immediately on 11 records.
Deeply obliged, Lordship. Next भी तुम्हारा प्रोजेक्ट है वो टाइमिंग होगा नेक्स्ट भी तुम्हारा नहीं 9 तुम्हारे आ जाओ ना Wait, please, your lordships.
Yes, ma'am.
Lordship, it's a contested matter, Lordship. In this case, Lordship, the petitioner has submitted few documents. Okay.
Because RMS H. Petala, counsel appearing for the petition. MS A. Verma, attending counsel, Department Assam for the number 2, 6 and 7. Mr. A. Ali, attending counsel election committee for the number 3. And Mr. P. Sharma, Government, Senior Government Assam for the response. Lead and Superintendent of Police ordered Kamrup Metro. But case number 2318 of 98, dated 22/04/2000. Made a reference against the petition pertaining to his national. Pursuant to the same, the learned member Fairness Tribunal Court Kamrup Metro in FTDPK in bracket M bracket close court. That's 1147 of 2018. After hearing party including the petitioner and considering the evidence adduced by the said petition by the impugn order dated 31/10/2023, opined that the petitioner is a foreigner under the Foreigners Act 1946, who had entered the state on or after 25/03/1971. Hence, this writ petition by the petitioner being dissatisfied with the said opinion dated 31/10/2023 of the learned member Foreigners Tribunal Court. Kamrup Metro. So notice return of them. It appear before Superintendent of Police. Not Superintendent of Police, Deputy Commissioner of Police. Metro. Deputy Commissioner of Police ordered Kamrup Metro Party authority for the same. Place this matter for admission immediately on this.
Much.
May it please your lordships. My lord, on the last previous occasion, your lordship directed my learned friend to produce the proof of service of those orders. Order dated 21st of December.
Because we are unable to take out the document, taking out the where he will deliver. My lord, we have already taken a initiative with the, department. Some,
Mr. Rathod, give us a date.
immediate after, Bihu, my lord. Because, 2017, my lord.
Or alternatively, your lordship may issue notice, my lord, because there is no question of any stay.
Let it be on 19th.
Thank you. 19th of January. My lord.
Heard Mr. M. K. Chaudhary, Learned Senior Counsel, assisted by Mr. M. K. Bora, Counsel for the petition. Also heard Mr. A. K. Datta, Learned Standing Counsel, Learned CGC for the respondent value. On the prayer of Mr. Datta, Learned CGC, matter we fix again on 19/01/2024 to apprise the court as to when the order was duly served by the railway on the petitioner. Order dated 13/10/13/01/2007 was duly furnished public served on the sole response. That's on the petition.
God bless you.
Petitioners, right? On the petitions.
I'm praying one day time. Muru, haircut, Muru. Just now I am getting the headshot. Record.
Prepare with Mr. T. Sharma, attending counsel from department. Matter be listed on 10.
10.
You are appearing for whom? For.
May I please, your lordship? In this case, your lordship, petitioner's own name has appeared in the voter list of 1971. Page 14, your lordship. Page 15 is the vernacular. তাই নিজের নামে আছে
Please make your submission. Babula. To make your submission. Sister is here. Come back.
In this case, your lordship, petitioner's own name, Fulgerness, appeared in the voter list of 1971.
Which page?
Page 14, type copy. And vernacular, page 15. Page 14 is bottom. You know, one's about Fulgerness, wife of Suziro Danglu.
Then?
Page 15 is the vernacular. But it was not considered due to discrepancy of age in the voter list. And father's names also I have annexed voter list. Page 12, father's parents' name. Page 12, Jalu Sheikh, fathers and mothers. Jalu Sheikh is the father, Shubha Khatun is the mother. Where the own name of the petition is appeared in the 1971 voter list. There is no question of clearing the, but it was not considered by the tribunal because discrepancy of age. The 71 is the cut-off date, and 71 voter list, her name appeared in the voter list. And generally, as January, it is considered as the enlisted. 25th March is the cutoff date of 71.
Is there any document that you being the daughter of so and so in the page
Lordship.
12? Is there any?
Page 12. I have
Page 12, you are saying that these are the protected parents of your.
parents,
Yes, sir.
parents name here. After her marriage, is the husband name is Kuzrat Ali is the husband. Page 14. In the year 9, I have stated paragraph 5. Page 4, paragraph 4, page 4, I have stated, marriage was solemnized in 1967 with Kuzrat Ali.
67.
67, marriage was solemnized with the Kuzrat Ali in 67. I have stated paragraph 4. And 1971 voter list, her name appeared with the husband. I have annexed that. Page 14. No, her name is appeared in the 71.
These two are the document.
Lots.
These two are the only document.
Yes.
No, page 12 and page 14 are the two documents only.
No,
Okay,
other
annex
documents
any
also
other-
there. Other documents also there.
Okay.
I have annexed. I have also land document of the husbands. And other documents also, I have voter list of page 1907, page 18. And page 16 is the land document with husband. Page 18 is the voter list of 1997 with husband. Kuzrat Ali, it is dated full Khatun. And now next page, voter list of 1997. Kuzrat Ali, full Khatun. Kulzar Nasser is written as full Khatun. Only vital look at 1971, her name is appeared. There's no question of doubt. And subsequent voter is there. And page, yellow page 49. It is a land document, your lordship. Your lordship got it, page 49. It's a land document with Kuljan Fatmanistas, daughter of Jalu Sheikh. Three sisters, I visited also WS also. Jalu Sheikh, and then Jalu Sheikh's name in the voter list of 1966. It's a Karachi Patka. And her own name has appeared in 71.
Has to prove her linkage with her father, not with her husband, Lordship.
Her name,
Lordship may kindly come to the opinion, Lordship. Lordship, I'll start from decision and reasons thereof, page 43. Page 43, Lordship. In this case, decisions and reasons thereof has Lordship found. In this case, no prosecution witness has been examined, but to prove herself not to be a foreigner, OP has submitted her evidence on affidavit. In her affidavit, OP stated that she's 67 years old and born in Topagaon, Part 2, village under Mirachar Police Station. OP stated that her father's and mother's name appeared in the voters list of 66 and 70 at village Topagaon, Part 2. OP further stated that her father expired before 42 years and mother expired before 40 years. OP stated that she got married before 50 years with Kudrat Ali, son of so-and-so of village Topagaon, Part 1. And in this respect, she submitted a certificate issued by the Secretary of Kacharipeti Gaon Panchayat, which is submitted as Exhibit C. OP stated that before 49 years, her husband, along with other family members, had shifted to village Mokhoa, Char under Bagbur Police Station in the district of Borpeta. OP stated that her name appeared in the voters list of 1971 additional at village so-and-so under Bagbur Police Station and submitted the said voters list as Exhibit D. OP stated that her father and mother's name recorded in the Kacha Patta and accordingly she inherited the said land as legal heir and submitted the Kacha Patta Chita as exhibits E, E1 and so respectively. OP further stated that before 42 years, she along with other family members had shifted to village Dumarguri and again before 37 years, she along with her husband shifted to Topagaon, Part 1. Lordship will kindly come to a just conclusion. Let me appreciate the evidence on record along with the aforementioned 10 documents to determine the nationality of the opposite party. From record, it appears that OP has projected Jalu Sheikh, son of so-and-so as her father and Subha Khatun, wife of Jalu as her mother, whose name appeared at village Topagaon Part 2 in the voters list of 66 and 70. Though OP has submitted the certificate issued by the Secretary of Kacharipeti Gaon Panchayat as Exhibit 3, she has not examined the issuing authority of the said certificate to prove the contents of the said certificate, and therefore the said certificate is not admissible and acceptable in the eye of law. OP has submitted additional voter list of 1971 as Exhibit D, wherein her name appeared as wife of Kudrat Ali at village Mokhowa Char under Bagabar Police Station. Exhibit E and E is the Kacha Patta and Chita of Patta number 182, wherein Shobha Khatun and Jalu Sheikh are shown as recorded Pattadar. In the said Chita, it has been recorded that Fuljan Nesa, Mohiran Nesa, and Tohiran Nesa has inherited a plot of land in place of Pattadar number 3, Exhibit E2, and the Kiraj Patta, wherein the OP's name appeared as the daughter of Jalu Sheikh along with Moiran Nesa and Tobiran Nesa. Though OP has submitted the Kacha Patta, Chita, and periodic Kiraj Patta of 182 and 184 of village Topagaon, she has not submitted the land purchase documents of the said land. OP has also not stated as to when her projected father and mother has purchased the land in question at village Topagaon because they were not resident of village Topagaon. OP has stated in her evidence on affidavit that before 42 and 40 years her father and mother expired, then who had paid the land revenue for the land in question? OP has not stated anything in this regard. OP has not submitted land revenue receipts of the said land. Moreover, the periodic Kiraj Patta has been issued for a period of 20 years with effect from 31st March 2009 in the name of Muhammad Jalu Sheikh, Fulijan Nesa, Mahirun Nisa and Tohiran Nisa, if the OP's projected father had expired before 42 years, then the said periodic Kiraj Pata would not have been issued to a person who had expired before 42 years. Thus, it is clear that Jalu Sheikh, whose name appeared in Exhibit So in the village, Topagaon Part 1, is not the same person whose name appeared at the village in the Topagaon Part 1 in the voter list of 66 and 70. OP's name appeared as Full Khatun and shown as 50 and 57 years old respectively. If OP was 57 years old in the year 2016, her birth year was 1959. If OP was born in the year 1959, she was only 12 years old in the year 1971, and her name would not have appeared in the voters list of 1971. But in the exhibit D, Fuljan Nesa is shown as 21 years old, hence it is clear that Full Khatun, whose name appeared in exhibit F, G, and H, is not the same person whose name appeared as Fuljan Nisa in exhibits D, E, and G. The OP has not been able to establish any link with her projected father whose name appeared in this voters list of 66 and 70. Lordship, the projected father and mother are only on papers. They are not the actual biological parents of the proceedee, Lordship. For the reasons and discussions above, the evidence and the documents submitted by the OP in support of a version are found not to be sufficient and trustworthy to prove that she is a citizen of India by birth and not a foreigner or illegal migrant. I'm relying on the opinion by the member Lordship. All the discrepancies have been very clearly and in a very detailed manner, it has been placed in this order. And there has been no explanation to that effect by the proceedee. The petitioner is only harping on the fact that 1971, her name appears with her husband, but there is not a proper, correct, reliable document to show her relationship with her father and mother, Lordship. It would be okay to read the document as a whole, voters list. On the basis of materials placed before the tribunal, this opinion, Lordship, has, I don't see any incorrectness in this opinion.
In this case, where the land document is there.
But land document has been explained very clearly, Lordship.
1971. This from your smoker, sorry. It is your smoker, sir. With the husband. With husband, your subject in Borpeta, your district. Did them come group, your did that come group? Subsequently, Borpeta.
Land document.
Bagbor, your 52 nang Bagbor. Lordship. Lord. Some full name Fuljan Nessa, Pita late Charu, Ame Kuzrot Ali, Tupkop Part 1, Thana Rongapani, Jila Boingao. Moi Jikom Hosakom, More ঘর টুপগাঁৱত মোৰ মা দেউতাৰ নাম ভোটাৰ তালিকাত কেতিয়া প্ৰথমে উঠিছে মই নাজানো 42 বছৰ আগতেই দেউতাৰ মৃত্যু হৈছিল আৰু তাৰ 2 মাহ পিছতেই মাৰো মৃত্যু হয়। 65 বছৰ আগতে মোৰ বিয়া হৈছিল। মোৰ স্বামীৰ ঘৰ টোপগাঁৱতে। বিয়া হোৱা দিন ধৰি মই টোপগাঁৱতে বসবাস কৰোঁ। ইয়াৰ বাহিৰে থকা কোনো ঠাইত মই কেতিয়াও বাস কৰি পোৱা নাই। 1970 চনত টোপগাঁৱত মোৰ নাম ভোটাৰ তালিকাত উঠিছিল। টোপগাঁৱত মোৰ নাম ভোটাৰ তালিকাত উঠিছিল। উক্ত তালিকা মই গোচৰত জমা দিছোঁ। মই এতিয়াও ভোট দি আছোঁ। মই এক্সিবিট ই আৰু এফ হিচাপে জমা দিছোঁ। পট্টা আৰু চিটাত উল্লেখিত মাটি কোনে কিনিছিল মই নাজানো। This lady sometimes illiterate lady coming person there. Sometimes them. When they came to court, you illiterate lady.
Not reliable and not correct,
The
Lordship.
old lady is 74 years. When they came to court. Reliability Lordship, that sometimes the illiterate person came to court, they are nervous, Your Lordship. When asking question, what question asked, first they said answer, they don't know. When she was asked that, I think she understood. But it might,
Actually, they're not nervous. They forget what the lawyers taught them.
that is, I think maybe she understand that prior to marriage, she was, he said at Toptown with her parents. Maybe that she understand that with the parents. Generally, question asks to the parents' name, there, what is the parents, where the paper live? And when question asks, maybe she understand that she was asked that with parents, which where she live. In
Did she
in
tell you?
petition, I have paragraph 5, 6, and 7, I have stated from where to where they have shifted in which year.
two book. And land document to new product. एक आरो बच्चों के माथे मालिक को documents select one better document out. Mas, नहीं उनकी डॉक्यूमेंट जो है आप एप्लीकेशन उसका पूर्ण छपा
that there is no cause of action for initiating the present proceeding against the opposite party by the prosecution in view of the fact that the opposite party is not a foreigner, such the proceeding is bad in law and principle. That the proceeding against the opposite party is not maintainable in the present form or manner. It is very relevant to mention here that the name of the father of the opposite party is wrongly mentioned in the notice served upon him, her, and the correct name is Zalu Sheikh and not the Tulu Sheikh. That the case, but a provision of estoppel and waiver, that the father of the opposite party, Muhammad Zalu Sheikh, son of Umaid Ali, and the wife name is Shubha Khatun, were permanent resident of village Gurgaon, and their names have been recorded and appeared in the list and certified translated copy of the electoral rolls, Assembly Constituency of Abhayapuri FCLA to Abhayapuri for the voter list of 1966 in serial number 1 and 2 against house number 1 respectively. Photostate copy of the aforesaid certified copy of the voter list for the year 1966 enclosed herewith this petition in support of the above contention for your honors kind perusal as ready reference as marked as annexer 1. That the opposite party was married to Kudrat Ali, son of Saib Ali of village Bagpur, under T.S. Borpeta of Jiddan district, Kamrup, in the first part of the 1970, and her name and the name of her husband are reflected in the certificate and state copy of the electoral rolls. Corrected Assembly Constituency 52 Bagbor LSC in voter list 1971, and so and so and so and so and so. Under Borpeta, Photostate copy of the aforesaid certificate copy of the voter list for 1971 is close here with this written still in support of the above contention for your kind perusal is ready reference as marked as annexer 1. That it is relevant to mention here that the photostate copy of the voter list for 1971 issued to the family of the Saib Ali to cast their votes in the election are also enclosed here with this written statement marked annexer 2A in support of the above contention for your house honors and perusal as ready reference. That the name of the opposite party and her husband, Kudrat Ali, are truly reflected in the certificate instituted copy of electoral rolls, Assembly Constituencies of Abhayapuri North of voter list of 1997 in serial number against house number 68 respectively. Photostate copy of the aforesaid certificate copy of voter list of 1997 is enclosed here with this petition in support of the above contention for your honors and perusal as ready references annexer 3. That the name of the opposite party and her husband, Kudrat Ali, are also reflected in the certificate translated copy in the electoral rolls, Assembly Constituency number 34 of Abhayapuri, in the voter list of 2008, against house number respectively. Photostate copy of the aforesaid certificate copy of voter list 2008 annexer 4. That the name of the opposite party is also reflected in the certificate translated copy of the electoral rolls, Assembly Constituency in 34 of Abhayapuri North, LSC in voter list of 2010 in serial number against house number 68 along with other family members. Photostate copy of the 2000 voter list is annexer 5. That in view of the facts and circumstances as stated above, it becomes crystal clear that the opposite party is a resident of village Post Office Gurgaon under PS Abhayapuri, district Gurgaon, Assam, and as such cannot be treated as a foreigner in the provisions of the Foreigners Act 1940. And the prosecution is against him is liable to and set aside. Three sisters. No, yours. It is not. Lots.
Hmm.
Made with the lordship. Lordship, with regard to item number 33, on the last occasion when this matter was taken up by your lordship had indicated that it would be taken up at 2 p.m. today. So can it be taken up at 2? It is not reflected in the causes, but lordships. Obliged.
May I please, Lord? I would like to mention item number 15, my lord. I'm sorry for that, lord. My senior is out of session, my lord. I'm today is not well, my lord. I'm trying to do the matter, but I'm not well, my lord. 15, my lord. Next week, 1 5, my lord. I'm suffering from cough, my lord. That is
This matter, or I think. That I- What is?
idea. Gujarat Ali. Village backward. Backward. Move first. Under Mozan is backward. Village. That's. That's.
Lordship, I would like to rely on some citations, Lordship, regarding the documentary evidence, Lordship. WPC 3807 of 2006, Lordship. Urmila Khatun versus Union of India. Yes, Lordship. This was decided on Lordship 18/6/2018. 8/6/2018. 18, Lordship. I decided. Citation is WPC 3807 of 2016, Lordship. I was wrong when I said that. It decided on 8/6/2018. Lordship, the paragraphs are not mentioned, but it starts with, it is tried the documentary evidence. It is on page 4 of 5 of the order. This order was passed by Justice Bhuyan and Justice Rumi Kumari Fukan, Lordship. Lordship will come to page 4 of the order, Lordship. The second paragraph, it is tried that documentary evidence, has Lordship found it? Her lordship has found it. It is tried that documentary evidence would have to be proved on the basis of the record, and the contemporaneous record must substantiate and prove the contents of the document. Proof of document is one thing and proof of contents is another. Not only the document would have to be proved, but its contents would also have to be proved. That apart, the truthfulness of the contents of the document would also have to be established from the record. A document or the contents of the document cannot be proved on the basis of personal knowledge. Lordship, I'm referring to this because there's a Gaubura certificate which is attached and it has not been proved at any point, Lordship. None of the documents which have been exhibited have been proved. And they are all photocopies, not the original ones, Lordship. So the petitioner has failed to prove his citizenship, Lordship, not only from the documents, but also by not bringing in any evidence, Lordship. And that certificate the Gaubura had issued, it was issued only on the basis, there is no record to show from where he has done it. Yes, Lordship. And the second one I would like to rely on is on the writ of circuitry, Lordship. 2020 SCC online. Itu kota sir. SCC online. SC 996. Paragraph 54 onwards, Lordship. Yes, Lordship. And one more we would like to rely on is 2010-13 SCC 336 Santlal Gupta, Lordship. Yes. Yes, Lordship. And another thing, morning, Lordship, I shared a judgment with Lordship. I would like to rely on that also. That was Lordship. Yes, Lordship, no steps taken, and then the jurisdiction of under 226 is limited. That's the last paragraph, Lordship, of WPC. Ex parte order, Lordship, taken ample opportunity granted. She filed her WS in 2013 only, never proceeded in the proceedings. Ex parte order granted, went back with the same documents not proved and declared a foreigner. There is no. Yes, Lordship. Submit. Yes. Not proved at all, Lordship. So I do not find any wrong in the opinion passed by the tribunal's order, Lordship. Mhm.
Lordship. Yes, Lordship. Yes, Lordship. Lordship. Sir, this, as regards translated copy, this has been stopped being issued by the electoral officers because the instruction was earlier directed by similar bench, Your Lordship, that no such translated copy should be issued. And accordingly, we have communicated to the department concerned and they have stopped issuing this, Your Lordship. Yes, Your Lordship, because. Your Lordship. Yes, Lordship. Yes, I can. Because there was, Your Lordship, on one hand, it was issued by the authority, but they had communications of error, I have to say, Your Honor, while issuing this one. Because as per 76 year, their name should also reflect, Your Lordship, along with their designation, the seal. Your Honor. Photo. Yes, Your Honor. Certified copies of public documents. Every public officer having the custody of a public document, which any person has a right to inspect, shall give that person on demand a copy of its on payment of the legal fees thereof, together with a certificate written at the foot of such copy, that it is a true copy of such document or part thereof, as the case may be, and such certificate shall be dated and subscribed by such officer with his name and his official title, and shall be sealed whenever such officer is authorized by law to make use of a seal, and such copies so certified shall be called certified copies. 15. Yes, sir. Yes, sir. No call karo. Name of the officer is not there. Not there. I pointed out this, Your Lordship, because my junior also informed me that Your Lordship has also on the earlier occasion has directed. I immediately communicated with the department, Your Lordship. Yes. Is not there. That cannot be, Your Lordship. Yeah. They are not meeting the demands of the section 77. Yes, sir. So, at present, Your Lordship, all the certificate copy that have been issued by the department are digital certificate. Lordship, their digital signature along with the name and digital signature is there, Your Lordship. The new, but just yes, Lord. Full name was hello. That certificate copy might have been obtained, Your Honor, prior to 2018. Yes, Lord. Obtained. That's what I'm saying. I've communicated that to Lordship. On yesterday itself, I've communicated them that while issuing certified copy, they should comply with all the directions and with the conditions mentioned in section 76. Published. Published. Yeah. May it the Lordship. এখন তো আছেন নাই এই ৰিট এপিলৰ ৰেকৰ্ডটো আছে না
আমাৰ সেইটো পুলিচ ভেৰিফিকেশ্যন
Equilibrium committee है, एक बार खाते ऑफिसर खाते हैं, रिपोर्ट लगी रहेगी। ಇದು ಮಾಡಿ नागेश्वर जजमेंट लेटर नहीं आगे সেইটো দেখা একদম ফার্স্ট পয়েন্ট and this is clarification to separate করতে নহয় NCL তো এতিয়া হৈছে আগতে লয়ে নাছিল now recently they have come up
Yes. I remember, let me paraphrase my thing, my lord. First, I will show my lord what is the scope of this inquiry. Whenever there is any doubt arises regarding caste certificate, then what is the manner in which that inquiry is to be conducted and by which authority? That is one. Now, let me address your lordship first on that, because a authority who is competent to make an inquiry has completed an inquiry. Based on that, my lord, nothing was found against me. Now, in such a situation, what is the option available? Now, my lord, will kindly see this Madhuri Patel's para 13, as Supreme Court has said in subsequent judgments, it is a complete code in itself. Now, my lord, what had happened in this case? The inquiry was conducted by the vigilance officer. Vigilance officer has rendered a report which is in favor of your present, our client, my lord. In spite of that, the state level committee, my lord, relying upon some report of circle officer and all, they wanted to take a contrary. In fact, a view was taken, which has been interfered with by the learned single judge on the plea or on the ground that the report of the vigilance officer says there is nothing wrong in issuance of certificate in favor of the candidate. Now, on last occasion, my lord, lordships had posed this very important query that where is the evidence or where is the material which was found by the vigilance officer that she is born and brought up in coast custom. That's a question which your lordships posed. Straight away I'll come to that, my lord. If your lordship will kindly come to this learned single judge's judgment at page 17, it starts of the review petition. If your lordship would kindly come to page 22. In the learned single judge's judgment, inquiry report of the vigilance officer is quoted. Yes. In respect of Srimati Monsoon Borkakoti, I'm sorry, my lord, page 22. In respect of Srimati Monsoon Borkakoti, I visited her paternal address and present address, that is Golaghat and Jorhat. In course of inquiry, it is found that father of the alleged, namely Dr. Khantanu Borkakoti, born and brought up at Silpukhuri, Guwahati, followed the original rights, that is rights of Kolita community, and got appointment as medical officer who was posted at Jorhat. Said doctor got married with a lady at Jorhat hailing from Koch community and used to reside at matrimonial house where alleged Miss Monsoon Borkakoti got birth at her mother's house on 12/4/1990, and since then she started her education at Jorhat and accepted the custom of Koch community. So I think this is what lordships wanted to know, because in that Supreme Court judgment para 54 and 55, this is precise Ramesh Bhai's case, my lord. This is precisely the requirement envisaged. During 2006, while she was student of class 10, she applied for OBC caste certificate on merit of her mother's custom. It is a fact that father of the alleged, though got appointment as MBBS doctor, however, he was not moved for OBC certificate as he was not born at Cox community. It is pertinent to mention herein that in respect of issuing OBC certificate, Honorable Supreme Court of India has passed a verdict referred to in so and so, this is Ramesh Bhai, that the child generally belongs to father's caste. However, the child can claim mother caste also in certain situation if the child is born and brought up at the house of her mother, who is hailing from other community than that of her father. It is a fact that judgment promulgated not directly related to OBC community. However, the situation incorporated carry the ingredients for which L.S. Monsoon Borkakoti is seen to be entitled for obtaining OBC caste certificate. Now, please come to the last subpara. As such, it is established that allegation brought against Srimati Monsoon Borkakoti, daughter of Santanu Borkakoti, resident of Club Road, Jorhat, is based on no truth. The complainant perused only the father's caste, but did not go through the real findings of the Honorable Supreme Court of India. My lord, for a moment, if your lordship will kindly have Ramesh Bhai's decision, my lord. That is 2012, 3 SCC, page 400. Para 55. At page 424, my lord, of the judgment. Para 55. Yes. In an intercaste marriage or marriage between tribal and non-tribal, there may be a presumption that the child has the caste of the father. This presumption may be stronger in case where in the intercaste marriage or marriage between a tribal or a non-tribal, the husband belongs to a forward class. But this is very important. But by no means the presumption is conclusive or irrebuttable, and it is open to the child of such marriage to lead evidence to show that she was brought up by mother who belonged to scheduled caste, scheduled tribe. By virtue of being son of a forward caste father, he did not have any advantage start in life, but contrary suffered the deprivation, indignities, humilities, handicap, etc., like any other member of the community to which he or his mother belonged. So, my lord, the Honorable Supreme Court said, normally a child will take the caste or tribe of the father. But in a given case where the child can show that he or she was born and brought up by the custom of the mother, then in which case, my lord, it can be given. Now, precisely this is the finding which was recorded by vigilance inquiry conducted by the concerned inspector. Now, what does Supreme Court say once there is a finding by the vigilance officer? That your lordships will get subpara 7 of my lord Madhuri Patil. Exactly, my lord. My lord, I'm just reading it. Lordship must have read it. In case the report is in favor of the candidate and found to be genuine and true, no further action needed to be taken, except her, etc., etc. So, normal circumstances, so that has to be accepted. Now, my lord, in this case, there is a finding recorded in favor of our client. Now, which is that material which impels the government to take a contrary view? Now, that is the issue, my lord. Now, my lord will kindly take please take the, my lord, review petition, sorry, affidavit filed by them, affidavit, additional affidavit filed by the state in the review petition. On 4/1/24. Please come to page 123, my lord. These are the materials which state seeks to rely upon for making out a case of review. I'll come to the scope of review little later. Let me place the facts. Para 3 at page 123. Supreme Court is a question chief minister এখন ওয়ারে কেস কে প্রিয় পারিব 69 or judgment দিবে বিহারের কেস দিবে in Purtapur. Ajay, Lordships got it, my lord. Yes, please come to page 123. That the deponent respectfully states that pursuant to the direction issued by the competent authority, the Superintendent of Police CID Assam Ulubari, by his letter dated 26/12/23, has submitted a detailed report on the status of the caste certificate in respect of Monsoon Borkakoti, as submitted by the inquiry officer Srimati Moromi Das. The aforesaid inquiry report submitted by the CID clearly indicates that Monsoon Borkakoti is not entitled for OBC certificate as her father belongs to general category and she received all kind of supporting from her father. My lord, I do not know who has directed this inquiry, records will reveal. Lordship knows the judgment of the Supreme Court in Kane Commissioner, that Purtapur company, where Honorable Supreme Court says, my lord, if for exercise of a particular power, an authority is prescribed, the Chief Minister has no other authority, my lord. Even if it is done by Chief Minister, in Purtapur's case, where we normally we refer as a, my lord, Kane Commissioner's case, where Supreme Court says that nobody can do it. It is only that secretary who is competent to in that case, my lord. So here it is the vigilance officer who will conduct the inquiry. Based on the report of the vigilance officer, the director vigilance will take a call, which in this case has already been taken. Therefore, in my humble submission, my lord, these materials cannot form the basis for furnishing any cause of action to the state to undertake any sort of review on the subject matter, my lord. Now, my lord will kindly his document will close. My lord will kindly come to page 172 of the additional affidavit, the same very pleadings. This is the part of the inquiry report, page 172, Annexure O. The Lordship's got it, my lord. Now, this is one letter by one president of All Assam Association. He is writing to the secretary of Golaghat and is seeking certain information under RTI. Then, please come to page, next page, my lord. Yes. No, no, my lord, what I'm trying to show, these materials were very much before the division bench, therefore review does not lie. I am on that. These material which they now they want to rely, these were very much before the division bench, my lord. That is what I want to show. Please come to my lord 172. This is 16/9/2019. This is a so-called report. Then my lord, these are the page 160, 173. Then my lord 174.
Certificate.
But these are allegedly fake certificate obtained by us, father. Then my lord, so from page 172 to 176, they claim this is what now CID has found out. So therefore, it furnishes them a fresh cause of action, which I'll show my lord. These materials were very much before the writ appellate court. Now, my lord will kindly take the records of the writ appeal. 149. Writ appeal 42 of 23, my lord. Please come to page 149. It is marked as Annexure E collectively. Kindly see page 149. This private party who preferred the writ appeal, my lord, all these documents were brought to the notice of the Honorable Court from page 149 to 155. Same very document. So therefore, my lord, if after perusing this document, the writ appellate court passed an order which according to the state is erroneous, then it is a province of appeal. It can't be the province of review by any legal reckoning. It's absolutely misconceived. Same document, my lord. So, my lord, the additional affidavit is based on certain documents which in the comprehension of the state furnishes them a fresh cause of action for seeking a review, to which our respectful submission is these documents are very much before the division bench, which dealt with the judgment under review. So therefore, my lord, by even going by that also, this cannot be taken note of. Now, my lord, I'll like to refer to two averments in the writ petition, which is in the writ petition itself, writ appeal. Please come to my lord, page 30 of the writ appeal. I'll read one paragraph, my lord. Now, I never claimed that my father is not general. I always said my father is general caste. And my lord, this certificate was obtained in the year 2006 when I was only class 9. I never knew, my lord, that one day I will appear for a civil service examination, then I will get into that. There is limit of harassing, my lord. In the name of doing justice, my lord, injustice should not be done. Para 4, page 30. It is humbly stated that as the, I'm sorry, my lord, page 30, para 4. It is humbly stated that as the marriage of the parents of the petitioner was an intercaste marriage, the family member of her father refused to accept the marriage in question, and thereby mother of the petitioner was subjected to many social evil prevalent in society. As such, mother of the petitioner was compelled to live in her ancestral home at Sekonidhora Gaon, Khelmati Club Road, Jorhat. Petitioner was born in Jorhat Civil Hospital now and was brought up amongst her maternal family members. Since her birth, the petitioner has been residing at the ancestral property of her mother, situated at Khelmati Club Road, Jorhat. Further, it is stated that the petitioner's mother never entered the government service as a master roll worker. Now, my lord, the projection of the state is, I'm a class 2 officer in the irrigation department, Jorhat, in the year 1988. Subsequently, in the year 2005, her services were regularized, and present she is working as senior assistant since 2018 of the said department. It is pertinent to state that petitioner's father is a government doctor by profession, and as such, he has served in different places of posting and had been staying in government quarter. From 88 to 2000, the father of the petitioner was posted at Khalikhat and so of Golaghat district. Thereafter, he was posted at Melamati PHC. In the year 2006, petitioner's father was transferred to Bokakhat. In the year 2008, petitioner's father was transferred to Dhonsiri and attached to so on medical ground. It is stated that petitioner's father had a bypass surgery in the year 2008. Eventually, father of the petitioner was transferred to Kamalabari PHC at Majuli, and till date he is serving there. Needless to say that petitioner along with her mother and her younger brother never stayed at her father's place, either in the state government quarter or at Guwahati. Sometimes during holidays, her father used to visit them in their maternal home at Jorhat.
Now he has retired.
And now, my lord, now in the meantime, he has retired. Now, these are the factual background which was very much before the learned single judge as well as before the division bench. Now, what is this, my lord? All of a sudden, some inquiry will be ordered. My lord, it can't be a never-ending business. Now, my lord, on this point, I'll just like to rely upon one unreported judgment of the Supreme Court, my lord, on the scope of successive inquiry. My lord, the name of the judgment is J. Chitra versus District Collector and Chairman State Level Vigilance Committee, Tamil Nadu. My lord, will kindly come to paragraph 8 at page 13. Has your lordship got it, my lord? Yes. Para 8, my lord, at page 13. In the instant case, an inquiry was conducted by the district level vigilance committee, which has upheld the community certificate in favor of the appellant. The decision of the district level vigilance committee in the year 99 has not been challenged in any forum. Kindly mark this, my lord. The recognition of the community certificate issued in favor of the appellant by district vigilance committee having become final, the state level scrutiny committee did not have jurisdiction to reopen the matter and remand for a fresh consideration by district level vigilance committee. The guidelines issued by letter dated do not permit state level scrutiny committee to reopen cases which have become final. The purpose of verification of caste certificate by scrutiny committee is to avoid false and bogus claims. Repeated inquiries for verification of caste certificate would be detrimental to the members of the scheduled caste and scheduled tribes. Reopening of inquiry into caste certificates can only be in case they are vitiated by fraud or when they are issued without proper inquiry. So, my lord, where is the scope? In fact, unless there is some enabling provision, the state level committee, my lord, do not have jurisdiction. That is the holding of the Honorable Supreme Court. So, in my humble submission, my lord, and lordship will also kindly note, supposing, my lord, in a given case, there is a scope for re-verification. Then, my lord, procedure prescribed in para 6 of sub-para 6 of para 13 will follow. That means it will be by the same vigilance officer. It will not be by any superintendent of police CID or at the instance of chief minister. Therefore, the whole thing is without jurisdiction. End of the day, my lord, in a 226 proceeding, what we challenge is the decision-making process. If a manner is prescribed for doing it, taking a decision, it has to be done in that manner, and any other mode of performance is altogether, my lord. Yes, my lord. My lord, Lordship will kindly permit me to place sub-para 7 of para 13 of Madhuri Patil, my lord, for a moment. Yes, it is there, my lord. Yes, Lordship is correct. Sub-para 7. At page 33 of the review petition.
Judgment কি নাম? এই মাত্র দিয়েছি।
Sub-para 7, my lord, at page 33. Yes. In case the report is in favor of the candidate and found to be genuine and true, no further action need to be taken, except where the report or the particulars given or procured are found to be false or fraudulently obtained. And in the later event, the same procedure as envisaged in para 6 will be followed. So in that case, the inquiry has to be entrusted to the vigilance officer, not to any other authority. Yes, my lord. Writ appeal, my lord. One second. Speaking order, my lord. Yes. Whereas learning, hearing Srimati, the state level scrutiny committee. Yes. Yes, my lord.
Yeah.
Given by that vigilance inspector. My lord. Sub-para 7. Yes. Maximum. Six. No, my lord. Yes, in a given case, what has fallen from your lordship, that could be the conclusion. But in this case, it is not, because, my lord, there was no flaw in the inquiry committed by the vigilance officer. Who has pointed out, my lord? My lord, some subject. No, lordship will kindly appear. No, my lord. No, my lord. It is very easy to say during further inquiry, some more materials have come to light. My lord, my entrance husband is doing all these things, my lord. My lord, no, we're on facts. We're on facts.
After report was suspend
No, lordship will kindly appreciate. After the, my lord, report, when SLC took a position that my certificate is forced, my lord, I was placed under suspension. Then I had to challenge that. It is under that circumstance, my lord, I had laid a challenge, and challenge has been upheld. And my lord, if at all, my lord will be kindly very, take note of this aspect. Assuming, my lord, what the learned Advocate General saying is correct, at best, my lord, it is a province of appeal. How can it be a ground of review, my lord? Let them go to Supreme Court and say the division bench was wrong. Let us see, my lord, how Supreme Court reacts. My lord, review is not the panacea for all, reversal of an order. No, my lord. A review can, in other words, they want a rehearing. Is rehearing a permissible in review jurisdiction? In effect, they are asking, my lord, merely because the Chief Minister has given a note, that by itself, my lord, may not be a ground. With all respect, I will submit. And my lord will kindly come to take the judgment, my lord. One more judgment. 2008, 8 SCC 612, para 21. Huh. 2006, 8 SCC 612. Now, my lord, in a review jurisdiction, sometimes discovery of new fact may permit review. Now, in what situation? I am on that, my lord. Please come to para 21. At page 633. At this stage, it is apposite to observe that where a review is sought on the ground of discovery of new matter or evidence, such matter or evidence must be relevant and must be of such a character that if same had been produced, it might have been altered the judgment. How is it relevant, my lord? The view of CID. So, at time, my lord, law is such a, my lord, progressing concept. We cannot give a restricted meaning, my lord. We have to give a very progressive meaning. Even giving the widest possible interpretation, my lord, that ground which is sought to be taken, that must be relevant. How, my lord, some subjective satisfaction of some officer or the Honorable Chief Minister will be relevant, my lord? Honorable Chief Minister felt that a non-deserving person should not get it. That is the subjective view of the Honorable Chief Minister, my lord. That cannot be decisive or conclusive on the issue. Now, in my humble understanding, subject to what your lordships may say, once the vigilance officer has rendered an inquiry, unless, my lord, there is an enabling provision, that's the end of the war. And, my lord, this division bench of this honorable court had applied its mind. I'll just, para 14 of the division bench judgment, kindly see, my lord. Para 14 of the DB judgment at page 37. Yes, yes, my lord. In the wake of the discussion made herein above, and keeping in view the categorical affidavit filed by the state government authorities before the learned single judge, placing on record the report dated, it was prepared after thorough inquiry conducted by vigilance officer. In the present case, under the supervision of Superintendent of Police CID, concluding that the allegation regarding falsity of social status certificate of Monsoon Borkakoti was based on no truth, the only course of action required to be taken as per ratio of the judgment in Madhuri Patel was to accept the said report of the vigilance officer, that is so and so. For the sake of repetition, it may be mentioned herein that state level scrutiny committee, while passing the impedance speaking order, did not objectively consider to the inquiry report of the vigilance officer. The inspector of CID, which was mandatory requirement as per the guidelines laid down by the Honorable Supreme Court in so and so. A perusal of the said speaking order would reveal that scrutiny committee, though referred to the report submitted by Superintendent of Police CID, but thereafter no discussion whatsoever was made to the findings of the inspector's report in the speaking order. On the contrary, while coming to the conclusion that respondent petitioner was not entitled to the benefit of OBC certificate, the scrutiny committee relied upon a parallel report which was not conducted through the circle officer Jorhat Revenue Circle. Apparently, in terms of the judgment in so-and-so, circle officer has no jurisdiction to carry out such an inquiry. Well, this is a conclusive finding on merit. Now, where is the scope of reviewing this, my lord? Why this view is wrong, my lord? If this view is wrong, then it is in the province of appeal. It can't be in the province of review. If it is wrong, it is wrong. Therefore, my humble submission is, my lord, the division bench has having rendered a, my lord, conclusive finding on each and every of the issues, my lord. I don't think, my lord, there is a scope for any review. Review lies in a very restricted area, my lord, and it's not a case for review. These are all finding on merit. Once there is a finding on merit, there is no scope for review. It can be re-hearing, my lord. And my lord will kindly come to page 184 of the additional affidavit. And division bench order, they have not, this honorable court has not passed any order in respect of that. Kindly see, my lord, how we are being subjected to different types of inquiries. But it is very easy for the chief minister's secretariat to put up a note, book an inquiry. Some anomaly can always be found out. That will not furnish any cause of action. It must be, my lord, I mean, something which emanates from the procedure prescribed. Whereas on receipt of a communication from page 184, my lord, of the additional affidavit. Whereas on receipt of a communication from Joint Secretary to the Government of Assam, Social Justice and Empower Department dispute regarding fresh inquiry done by CID on your caste certificate, whereas Superintendent of Police CID has submitted the inquiry report on the status of your caste committee as doubtful, which was carried out by inquiry officer Ms. So-and-so, so-and-so. Who is this Moromi Das, my lord? She is not envisaged in Madhuri Patil. Whereas in persons of directives of the Honorable Supreme Court in Madhuri Patil, how they can claim to draw any source, my lord, from Madhuri Patil when she speaks to the contrary. Therefore, before any action is warranted against you, you are hereby given 2 weeks' time from the date of receipt of the show cause notice to explain the reason which led you to obtain a caste certificate of a caste to which you do not belong. Is it, are they not showing disrespect to the authority of this honorable court? The judgment is holding the field today, my lord. Can they start parallel proceeding like this? Therefore, my humble submission is, my lord, it's a overzealous act on the part of the state, which your lordship will not permit. More particularly, my lord, when it is a case of review. I can appreciate, my lord, against the order of the single judge, a writ appeal is preferred, then your lordship finds enough grounds to interfere. That's a different area. But in a review jurisdiction, my lord, that too based on some subjective satisfaction of some authority, lordship will not permit this, my lord. Otherwise, my lord, people will lose faith in the system. My lord, one more point. Yes, I must point out. My lord, basically they are seeking review on 3 grounds. 2 grounds I have shown, my lord, which were already there. Now the 3rd ground, which they have suppressed. Now please come to, my lord, page number 118 of the affidavit in opposition filed by us in the review petition. Because this is also one of the, document which they have taken note of. No, my lord, letter by the office of the Deputy Commissioner's office clarifying the position at page 118. My lord, as me is, may I read my lord vernacular at page 119? Through Jonohongjok Jorhat at page 119. যোৰহাট জিলা উপায়ুক্ত ৰশ্মি অপৰাঞ্জী কাৰ্তিৰ নামত কোনো অচিনাক্ত ব্যক্তিয়ে যোৱা 26 মাৰ্চ 19 তাৰিখে যোৰহাট ক্লাবৰ ৰোডৰ মনসুন বৰকটেৰ নামত এখন ভুৱা চৰকাৰী পত্ৰ প্ৰেৰণ কৰে। এই ক্ষেত্ৰত উপায়ুক্ত গৰাকীয়ে যোৱা 30 এপ্ৰিলত উপৰোক্ত অচিনাক্তি ব্যক্তিজনৰ বিৰুদ্ধে যোৰহাট সদৰ থানাত এটা গোচৰ দাখিল কৰে। কিন্তু যোৱা কেইদিনমানৰ পৰা কেইখনমান বাতৰি কাকত জিলা উপায়ুক্ত গৰাকীয়ে মনসুন বৰকাকতিৰ বিৰুদ্ধে যোৰহাট সদৰ থানাত গোচৰ তৰা বুলি উল্লেখ কৰাটো উপায়ুক্ত গৰাকীৰ দৃষ্টিগোচৰ হৈছে। উপায়ুক্ত গৰাকীয়ে মনসুন বৰকাকতিৰ নামত কোনো পত্ৰ প্ৰেৰণ কৰা নাছিল আৰু তেওঁৰ বিৰুদ্ধে থানাত গোচৰ তৰা নাছিল। তেওঁৰ নামত অচিনাক্ত ব্যক্তিহে ভুৱা চহীৰে পত্ৰ প্ৰেৰণ কৰিছিল বুলি উপায়ুক্ত গৰাকীয়ে জানিবলৈ দিছে। আনহাতে উপায়ুক্ত গৰাকীয়ে ভুৱা চহী কৰা অচিনাক্ত ব্যক্তিজনৰ বিৰুদ্ধে সৰব হৈ উঠিছে আৰু এই ব্যক্তিৰ ওপৰত তৎকালে বিহিত ব্যৱস্থা গ্ৰহণ কৰিবলৈ আৰক্ষী প্ৰশাসনক আহ্বান জনাইছে। In the name of Deputy Commissioner, some reports have emerged in the newspaper saying that, my lord, I have acquired false certificate and that, my lord, some cases has been registered. The Deputy Commissioner himself had to clarify. And these are the materials which they have taken note of. Therefore, my humble submission is, my lord, it's a case where lordship will dismiss the review petition by awarding exemplary cost. This is no way, my lord, a review petition is required to be filed. That's my humble submission. My lord, normally we have filed an objection. Anyway, my lord, that I leave it to lordship. I'm not very fussy about that. On merits, my lord. In fact, my lord, when your lordship exercises the power of review, it is also under, my lord, 226. Therefore, since normally, my lord, in 226 petition, there is no question of application of Limitation Act. Perhaps, my lord. I'm deeply obliged, my lord. With the lordship's kind permission, can I take it? Deeply.
So my response will be on every point which my learned senior friend has just raised. The first was, he referred to a judgment of Supreme Court 2012, 3 SCC, page 400, paragraph 55. Yes, now that is where the main crux of the matter remains. The main crux of the matter remains here is whether she was brought up by the mother singly or by her parents. That is the core issue. Division benches. Yes, Lord. Will 7. In case the report is in favor of the candidate and found to be genuine and true, no further action needs to be taken except all the state governments, this one, Lordship. 4. All the state governments shall constitute a committee of 3 officers, namely Additional Joint Secretary, then Director Social Welfare, then in case of scheduled caste, another officer who has intimate knowledge in the verification and issuance of the social status certificate. In case of scheduled tribes, the research officer who has intimate knowledge in identifying the tribes, tribal communities, parts of and groups of tribes or tribal communities. Each directorate should constitute a vigilance cell consisting of senior deputy superintendent of police in overall charge and such number of police inspectors to investigate into the social status claims. The inspector would go to the local area of residence and the original place from which the candidate hails and usually resides, or in case of migration to the town or city, the place from which he originally hailed from. The vigilance officers would personally verify and collect all the facts on the social status claimed by the candidate or the parent or guardian, as the case may be. He should examine the school records, birth registration, if any. He should also examine the parents, guardians, or the candidate in relation to their caste, etc., or such other person who have knowledge of the social status of the candidate, and then submit a report to the directorate together with all particulars as envisaged in the pro forma, in particular of the scheduled tribe relating to their peculiar anthropological and ethnological traits, deity, rituals, customs, mode of marriage, date, ceremonies, method of burial of dead bodies, etc., by the caste or tribes or tribal communities concerned. The director concerned, on receipt of the report from the vigilance officer, if he found the claim of social status to be not genuine or doubtful or spurious or falsely or wrongly claimed, the director concerned should issue so cause notice, supplying a copy of the report of the vigilance officer to the candidate by a registered post with acknowledgement due, or through the head of the educational institution concerned in which the candidate is studying or employed. The notice should indicate that the representation or reply, if any, would be made within 2 weeks from the date of receipt of the notice, and in no case on request not more than 30 days from the receipt of the notice. In case the candidate seeks for an opportunity of hearing and claims an inquiry to be made in that behalf, the director, on receipt of such representation, reply shall convene the committee and the joint additional secretary as chairman, who shall give reasonable opportunity to the candidate, parent, guardians to adduce all evidence in support of their claim. A public notice by beat of drums or any other convenient mode may be published in the village or locality, and if any person or association opposes such a claim, an opportunity to adduce evidence may be given to him, it. After giving such opportunity either in person or through counsel, and the committee may make such inquiry as it deems expedient and consider the claims vis-a-vis the objections raised by the candidate or opponent and pass an appropriate order with brief reasons in support thereof. In case of the report is in favor of the candidate and found to be genuine and true, no further action needs to be taken except where the report of the particulars given are procured or found to be false or fraudulently obtained, and in the latter event, the same procedure as may be emphasized in the paragraph 6 to be followed. So there are two components here, very important, which was never argued by anybody now. 7 says two situations are contemplated here. In case the report is in favor of the candidate, then that is one event. And also, so if it is in favor, but it is not genuine, according to the committee, then they can follow the same procedure as 6. There are 6, but that was done. These are all gone. Lordship. Yes, Lordship. On top of, yes, Lordship. Yes, Lordship. These aspects are not there. If Lordship goes to that report, if I am allowed to place that, it is a very mechanical and cryptic report without any details as contemplated in paragraph 5. All these things have come out in the recent report. My review is difficult. My ultimate prayer would have been whatever has fallen from this honorable court's mouth, that it has to be remanded back to the committee. What we are doing now, we are issuing a fresh so cause notice to her on the basis of the 26th December 2023 report. Yes, that power is there because till now we did not have power, but there is no bar. But this Supreme Court judgment, which my learned friend has just cited, that's judgment, J. Chitra's case, the last line, that is the power. That is the power. The paragraph 8, I think the last line of that paragraph. Otherwise, till now, we are proceeding on the basis that there is no bar because the government has seen that the report is not proper, the material facts are not there. Prima facie, there is a dispute whether she was brought up and her upbringing was with her mother singly or with her parents who are living happily. This is the whole area. Because if you look at the office memorandum of the central government, it very clearly says all these benefits of getting a certificate on the basis of mother's caste is that she should be divorced or she should be single or she should be separated. And she should be singly brought up by the mother, paragraph 54 of that judgment also, which my learned friend showed, paragraph 55, only by mother. The learned single judge division bench all along proceeded on the premise that she was actually brought up by her mother singly. If Lordship is pleased to look at the records, when the deputy commissioner's officials went to her home, every time the parents were there, they met the parents. I can give number of times in this report. Every time they went to their parents, to her house at Club Road in Jorhat, every time the ADC and the other officials found the parents were living together, they refused to give any certificate. But all the time, the father and mothers were found together. And what she has written in her writ petition, which my learned friend today read out, that they were separated, all these things, this is where they have lied before this honorable court. That is not based on truth. Paragraph 4, they have said, page 30. It is humbly stated of the record. So that is where, and the vigilance officer in the earlier round of investigation did not enter into that arena. If Lordship is pleased to look at his findings, which is quoted in the judgment, paragraph, page 22. May I read it, Lordship? Here where the fault is there. In respect of Monsoon Borkakoti, I visited her parental address. So parental address is very clearly says, which my learned friend has read in a different manner. And the present address, that is Golaghat and Jorhat. In course of inquiry, it is found that the father of the alleged, namely Dr. Santanu Borkakoti, born and brought up at Silpukhuri, Guwahati, followed the original rights, that is of Kolita community, and got appointment as medical officer who was posted at Jorhat. The said doctor got married to a lady at Jorhat hailing from Koch community and used to reside at matrimonial house. Here also it is very clearly says, used to reside at matrimonial house wherein the alleged Miss Monsoon Borkakoti got birth at her mother's house. It was not her mother's house, it was her parents' house. This is the new finding. When the husband and wife resides together with their children, all their children, it is their parents' house, it is not their mother's house. And that is found out in the subsequent, because a new house was built, they were all living together. The father was instrumental in constructing that house. These are told by their own relatives to our officer, who are residing nearby, adjacent plots. So when we compare these findings with the present finding, there is a hell lot of difference. There are a lot of additional facts which have come out and which we can find a resemblance from the paragraph 5 of Madhuri Patil's case, paragraph 13(5). What are the details are required? These details are not here. And therefore, this judgment, Chitra. Yes, Lordship, I'd like to read it out. When the inquiry is not proper, the line, it was on a different context, the district level and the state level. So in this case, Chitra's case, the Supreme Court says that when a district committee finalizes a particular certificate, the state committee has no power to reopen it. That is the ratio. But while doing that, that observation is given. Here, paragraph 8, last line, reopening of inquiry into caste certificate can only be done in case they are vitiated by fraud. Apparently, we have found fraud here, or when they are issued without proper inquiry. So in our case, it is not proper inquiry. What the Chief Minister said, Chief Minister said that whether the SP, CID has done the inquiry properly or not, whether there was any malafide intention, whether there is any misdeed, misconduct, that inquiry the CM ordered to find out. The finding was that the CID or SP was correct. He gave the report on the basis of the report submitted by the lower level officer who was the vigilance officer. The vigilance officer's report does not have any material facts which are contemplated under paragraph 13, subparagraph 5. Thereafter, the authority decided that go for fresh inquiry in the month of December. Suppose the inquiry officer, suppose after the Chief Minister's note of June 2023, it was found that whatever the vigilance officer has done, it was correct and there is no fault in the inquiry. That would have been the end of the chapter. She would have been reinstated and this whole episode would have been closed forever. But when the finding was come out that the officer who was entrusted to do inquiry in 2019, he was more relying on the judgment of the Supreme Court than the fact-finding exercise. What he has said later on, Lordship, we'll kindly come to page 23 once more. During 2006, while she was a student of class 10, she applied for OBC caste certificate on the merit of her mother's custom. It is fact that the father of the alleged who though got appointment as MBBS doctor, however, he was not moved to for the OBC certificate as he was not born at Koch community. It is pertinent to mention here that in respect of issuing OBC certificate, the Honorable Supreme Court of India, so now he has become a judge there. He has become a judge. Now we have to say, his role was to find out the facts. He find out the law. He found out the opinion of the Supreme Court. Passed in the verdict referred in so-and-so on 18 January, and in connection with appeal of Supreme Court of India past judgment, the child generally belongs to father's caste. The child can claim mother's caste also in certain situation if the child is born and brought up at the house of the mother who is hailing from other community than of her father. It is the fact that the judgment promulgated not directly related to OBC community. However, the situation incorporated carried the ingredients for which alleged Monsoon Borkakoti is seen to be entitled for obtaining caste certificate, OBC. Moreover, the issuing agency clarified that the certificate issued is genuine and issued from their office. So, he did not went into the details. No fact-finding exercise. What is contemplated in paragraph 5? Paragraph 5 says, paragraph 5 very clearly says, very detailed, that once it is given, the inspector would go to the local police place of residence. I'm sorry, I'm reading from the first line. Each directorate should consider a vigilance cell consisting of senior deputy superintendent of police in overall charge and such number of police inspectors to investigate into the social status claims. The inspector would go to the local place of residence and the original place from which the candidate hails and usually resides, or in case of migration to the town or city, that's place from which he originally hailed from. The vigilance officer should personally verify and collect all the facts of social status claimed by the candidate or the parent or guardian as the case may be. He should also examine the school records, birth registration, if any. He should also examine the parents, guardians, or the candidate in relation to their caste, etc., or such other persons who have knowledge of the social status of the candidate, and then submit a report to the director with all the particulars. These particulars are missing in our case. As envisaged in the pro forma, in particular, of the social tribes relating to their peculiar anthropological and ethnological traits, deities, rituals, customs, mode of marriage, dates, ceremonies, etc., etc., etc. So, he has not said anything regarding any of the areas where he has to conduct the investigation. That is why the word perfunctory is used, that the inquiry was perfunctory in nature and therefore he should be brought to task. And therefore he is now facing departmental proceeding as well as he is put under suspension. And he has annexed the Supreme Court's order in his report. And I am told, Lordship, during her, after she got her this service in the Revenue Department, Lordship, in her police verification report also the address is shown as Silpukhuri. But that record I will have to place maybe today in this review, it may not be very relevant. But in our inquiry, that will be very relevant because for her police verification also, Silpukhuri's address is given. She stayed in Silpukhuri for 6 long years, from 2009 to 2015. The fathers resided in Jorhat permanently by constructing a house. The land may belong to the wife, but it was a joint venture and they are happily living, Lordship. So this memorandum issued by the central government, Lordship, which I have annexed and placed it on the other day. Page 181. In what situation the mother's caste can go to the daughter or the son? So 3/10/2019, the central government's notification. For the sake of repeating, Lordship, there is relevancy, that's why, because the core issue is whether she was brought up with her mother singly or with her parents in a happy family situation. The subject is caste status of offspring of separated, divorced or single woman. Whether Runumi Datta, na? Makonam? Purnima Datta is a single woman, a divorced woman or separated woman. That is the core issue. The police officer ought to have found out that very relevant status instead of finding the Supreme Court judgment. And before going there, Lordship, page 140 of the writ appeal. Lordship will kindly see now. Everything is getting very clearer. Page 140 of the writ appeal. 42/2023. Page 140, Annexure B. It's a part of the writ appeal, but whether it was annexed with the writ petition or writ. Yes, page 140. It was filed with a complainant and have Lordship got it. The middle portion, candidate's address, Lordship will kindly see. And as the earlier vigilance officer did not inquire into all these things. Monsoon Borkakoti, Chandrabala Borua Lane, near SBI Evening Branch, house number 107, Silpukhuri, Chanmari, Kamrup, Guwahati, 781003. The father may have stayed in Jorhat because his place of posting was nearby, in the vicinity of Jorhat. In fact, here also Lordship will kindly see the mother's name. Mother's name is Purnima Borkakoti. The mother has also adopted the father's caste. Daughter has also done it. And rightly done, Lordship. Her brother till now is a general candidate. Till date is a general candidate. Mother, I do not know from where her record shows that in 2005, at the time of regulation, she was shown as OBC. She got her OBC certificate in 2019. Only for the sake of the daughter's status, they are doing all this. And I have already produced the materials, Lordship, the other day. How the father applied for OBC caste certificate on the basis of his residence, temporary residence in Dergaon. He also applied and he took a certificate also of OBC. So seeing all this abundantly clear black and white materials on record, can the government close their eyes? It is not subjective opinion of the Honorable Chief Minister. The Honorable Chief Minister only said that find out whether the inquiry was properly done or not. The note says that they have annexed it, Lordship, the other side. Put a second. Affidavit in opposition by them, the note is there. We get it. Lordship will kindly come to page 117. May I read it, Lordship? Once.
এখন তোমার দিম আপনার ফটো দেখাই দাও
এক মাহ দিছিলে, এক মাহ থাকিলে আৰু ঘৰলৈ গৈছিল। সেইটো এনকোৱাৰী দেখাব আপুনি আমাৰ কাউণ্টাৰ ডিউটি ইয়াতে
এডমিট কাৰ্ডখন দেখালে তাতে চেণ্টাৰ আৰু ভেন্যু এড্ৰেছটো নেদেখালে।
Page 117. One 40. One 40. Yes, Lordship. Yes, Lordship. Yes, Lordship. Paragraph 159, paragraph 7. The statements made in paragraph 6 of the affidavit filed by respondent number 7 being matters of record, the petitioner does not admit anything which is not borne out of record. Further, the averment made in the first paragraph of the affidavit in opposition supports the contention of the petitioner. As regard the good bonding of the petitioner with her father's family is concerned, the petitioner fails to understand as to how such good relation disentitles her from having an OBC certificate. We are not on that. Fathers with father, she has a good relation. The mother also has a good relation. Exactly, Lordship. That is the indication. Yes. Yes. Absolutely, Lord. Yes. Further fortified that stand, our stand. because they are saying that it is Chief Minister's subjective opinion. That is why the inquiry is conducted. Yes. Yes. Page 117. It appears that the authenticity of the OBC status of Sri Monsoon Borkakoti is in serious doubt. While I fully respect the majesty of the the affidavit filed by them, opposition. Affidavit in opposition by the respondent. OP number 1. I am committed to complying the direction of his so and so. In this backdrop, a prayer has been made before the Honorable High Court to grant state only 15 more days to take a decision on either implementation of the order of the Honorable High Court or to file a review petition in Honorable High Court or the Supreme Court with the bona fide intention of upholding fair play and justice to all concerned. Further, so and so may be requested to accompany so and so during his appearance in Honorable High Court and place the full facts before the Honorable Court, as well as submit there is no willful lapse on the part of so and so in complying with the direction of the Honorable Court. A meeting may be immediately called. This is a note of 1712. Now let us go to the note of the June month. Do not note from the records. Find out who's fault. Whether CID has conducted the inquiry properly or not. I'll place that, Lordship. In that note, it is very clearly said, find out whether there was any default on the part of the inquiry. And before going that, this judgment of 2012, 3 SEC page 400. Paragraph 55. Paragraph 55, Lordship. In an intercaste marriage, or marriage between a tribal and a non-tribal, there may be a presumption that the child has the caste of the father. The father may be stronger in the case where it is the intercaste marriage or marriage between a tribal and non-tribal. The husband belongs to a forward caste. But by no means the presumption is conclusive or irrebuttable, and it is open to the child of such marriage to lead evidence to show that she was brought up by the mother. This is what I am trying to highlight, Lordship. Only by the mother, who belong to the scheduled caste, scheduled tribe. So whole case is relied on the basis, on the premise that the mother has singly brought up or groomed the child. In our case, and the Honorable Division Bench as well as the single judge went ahead with the premise that she was singly groomed by her mother only. That is why, if Lordship is pleased to come to the submission of the learned senior counsel in paragraph 4, page 30. Of the, yes, page 30 of the review petition. Their submission as well as the police vigilance officer's report are on the same page. Last line. However, based on the fact that the girl child was residing with her mother and was following the customs and rituals of Koch community, a certificate dated so and so was issued in favor of the respondent writ petition affirming she belongs to Koch community. And on the basis of this, the learned the division bench at paragraph 14 Paragraph 14, in the wake of the discussion made herein above and keeping in view of the categorical affidavit filed by the state government authorities before the learned single judge, placing on record the report of 3/10/2019, which was prepared after thorough inquiry, whether it was thorough or not, now it is coming out, Lordship, after the second inquiry, conducted by the vigilance officer, that is Inspector of Police CID Assam in the present case, under the supervision of the SP CID, concluding that the allegations regarding falsity of the social status certificate of Monsoon Borkakoti was based on no truth. The only course of action required to be taken as per the ratio of the judgment in so-and-so was to accept the report of the vigilance officer. For the sake of repetition, it may be mentioned that the state level committee, after while passing the impugned speaking order on 26/2/2021, did not objectively consider the inquiry report of the vigilance officer, that is Inspector of CID, which was mandatory requirement as per the guidelines. Now coming to paragraph 15. Testing the report of the vigilance officer, the Inspector CID on the touchstone of the principles laid down in the case of Kumari Madhuri Patil, we find that the inquiry report submitted by the Inspector CID does not indicate even in the slightest that the particulars given by the candidates were false or that the social status certificate had been fraudulently obtained. Paragraph 4 of the writ petition, she says she stays with the mother, there is separation, and the father's family never accepted her mother or her. Here, the Honorable Court believed the report of the vigilance officer and considered it to be as truth as the Bible. Now, in our second inquiry, we have come to know that there is no genuineness or truthfulness in the said report. From the detailed inquiry, after the new vigilance officer visited all her places of residence, their ancestral places, meeting their family members, meeting them, verifying with the various competent authorities, come to the conclusion that there is no separation between the husband and wife, and they were happily living in Jorhat. The parents are keeping their children, both the siblings are living together in Jorhat. The projection as given in paragraph 4 of the writ petition is absolutely incorrect. Therefore, the vigilance officer report, which is on the same page with the statements made by the writ petitioner in paragraph 4, cannot be further accepted, and therefore the fresh inquiry was done on an order passed on 13th of December 2023, and on 26th the report was submitted, and which is a part of the additional affidavit today. Yes, I do. Yes, this is. One more. There is one more.
79 or 93, that's it. 93. Serial number 93. Serial 93.
Yes. Page 79 and page 93 may kindly be seen. My friends, Dr. Misailva. 79, note sheet number 79. This was in the month of March 1st. Then in 1993, in the month of June, that is 14 June. The Chief Minister never issued any direction for fresh inquiry. What the Chief Minister said, the Principal Secretary, Home and Political Department may ask ADGP CID to examine whether there was malafide intent or misconduct on the part of the concerned SP and the inspector with reference to the observations of the Advocate General in his opinion dated 19/5/2023. Lordship may kindly see this. So while doing the verification to find out whether the SP and the subordinate officer has rightly done or not, then all these facts have come out. So there is no question of subjective opinion of the chief minister. This is a procedure. No. The contempt was now contempt we are facing the hit. Contempt. In fact, there is no contempt, lordship. All along we are trying to implement, but before implementation, we have to see how a Borkakoti gets the benefit of an OBC. That is our concern. And when we have found that the father is also trying to get the same certificate, being a Kolita person. In that file, lordship will find lot of notes when the ADC went to verify the certificates in 2018-19. Every time the ADC found the parents living together in the house. But they refused to cooperate. Inquiry report, inquiry order. Order. That is William. 184 Lordship. Yeah, it's a person support as well. Review this. It is for the person report. Hmm? Page 54. Helpful. Lordship. So after that, the Lordship will kindly take the review application. After the Chief Minister's note, the enquiry was done. Page 49, Lordship will kindly see. This is a letter of 14/11/2023 to the Secretary, Personnel Department. With reference to the subject cited above, I am directed to inform you that as stated by the Office of the Additional Director General of Police CID Assam, by letter memo dated 7/8/2008, there was no mala fide intent or conduct on the part of the Superintendent of Police CID in connection with the enquiry. Necessary enclosures in this regard as furnished by Office of the ADGP is attached here with in favor of your kind necessary action. So here the first letter says CID SP has no mala fide intention. Now next page. The AIGP and the Inspector General of Police CID wrote to the Additional Secretary to the Home 7/8/2023, submission of enquiry report dated so and so. HMA letter dated 22nd June 2023. With reference to the subject cited above, I would like to inform you that an enquiry was conducted into the matter. The enquiry was conducted by Punamjit Nath, APS, Deputy Superintendent of Police. The enquiry revealed that Inspector Dibbojyoti Dutta, the then inspector, had made a perfunctory enquiry. However, it has been ascertained that there was no malafide intent or conduct on the part of the Superintendent of Police CID Assam. The enquiry report along with the enclosures submitted by the enquiry report are attached herewith and forwarded for your kind needful action. So it was the finding after that Chief Minister's direction that CID SP was not at fault. The fault lies with Inspector Dibbojyoti Dutta because his enquiry was found to be perfunctory. And the enquiry report, page 51, subsequently, it starts from, the relevant portion starts from serial number 5. Inspector Dibbojyoti Dutta had submitted an enquiry report to the Superintendent of Police CID on 3/10/2019 in response to the above mentioned letters received from Director of Welfare of Plain Tribes and Backward Classes. The detailed observations are herein below. The OBC certificate issued to Monsoon Borkakoti by All Assam so and so, dated 13/6/2006 and countersigned by the ESC. The name has been mentioned as Monsoon. Spelling is wrong. Diganta Borua, village headman of Sekonidhora, etc., under whose jurisdiction Monsoon Borkakoti currently resides, had provided a copy of the letter he received from Sri Surendranath Bora, the then village headman of so-and-so Gaon, informing that late Sivaprasad Borkakoti, father of Santanu Borkakoti, along with his family, was residing in so-and-so Gaon, Mouja, Misamari district, Golaghat, before 1950, and they belonged to Koch community. So the father was also Koch. His report. Sri Surendranath Bora, the then village headman of Doirongia Gaon, denied issuing any such letter confirming that they belong to Koch community, thereby contradicting the statement of Diganta Borua, village headman of Sekonidhora Gaon, East Revenue Circle. So the subsequent inquiry revealed all this, the two conflicting reports. Monsoon Borkakoti had received a letter dated 26 March 2019 from the DC Jorhat asking her to bring the original documents for verification. Later, the aforesaid letter was found to be fake. A police case was registered. Following the points were not incorporated in the earlier EO's Inspector Dibbojyoti Dutta of CID in his report submitted to Superintendent of Police CID dated 3/10/2008. The above mentioned observations may have been taken into account if deemed fit in ascertaining the malafide intent on the part of the previous EO. So once this was received, this was 31/7/2013, and from the CID, the letter was received. Thereafter, the government had hastily decided on 11th of December, this is the letter, Lordship. Now, when all these findings have come out, then the Chief Minister directed for inquiry. So 11th of December, that order was issued. Lordship. Yes, Lordship. Because all these findings, let them challenge our reopening. then in that case, we can definitely argue. But it can be definitely reopened because the judgment which they have relied. Otherwise, there is no bar, even without this judgment. When all the facts are coming into light, that whether she stayed with her parents or she stayed singly with her mother, that is the core area where the issue of issuance of OBC or entitlement of OBC certificate depends. When a contra view has and contra finding is out now. So therefore, the inquiry has to be done properly. And again, we have to go through the same process of paragraph 13. Therefore, the SOCOS notice was also issued. Inquiry was conducted. They have participated to the inquiry by the new incumbent, Moromi
Now,
Das.
whether it will be a ground for review.
No, I'm not on that. The findings are a ground of review. Findings are a ground of review because on the premises on the basis of which the learned single judge as well as the division bench went ahead and granted relief to the writ petitioner. Now that whole basis is crumbling after the new findings. Therefore, the subsequent development, evolvement of new facts are good grounds for review. Therefore, at this stage, my humble submission is that Lordship may be pleased to admit this appeal, review application, issue proper notice to them, and fix the matter for final disposal. And in the meantime, Lordship may be pleased to keep the impugned judgment on hold. That is my prayer at this stage. Not to say, because if Lordship allows, then we'll re-argue the whole case. And therefore, on the other document which I was placing, because it is the single mother or divorced or separated mother whose children can, page 181. Page 181. Issued by the Social Justice and Empowerment Department of the Government of India to all the chief secretaries of the various states and union territories, subject caste certificates, caste status of offspring of separated, divorced and single women. I am directed to say that comprehensive legal position about the status of offspring born to couples where one or both of the spouses is or are members of SC or ST was circulated by the Ministry Home Affairs dated 21/5/1977. This is of 3rd October 2019. It has been represented to this department that the said guidelines are silent regarding caste status of offsprings of separated, divorced single women, that is whether caste certificates can be issued to the children of separated, divorced or single women on the basis of caste of their mother. In Supreme Court in Ramesh Bhai, Dabal Bhai Naika versus State of Gujarat stated, in an intercaste marriage or marriage between a tribal and non-tribal, there may be presumptions that the child has the caste of the father. These presumptions may be stronger in case where the intercaste marriage or marriage between a tribal and non-tribal, the husband belongs to a forward caste, but by no means the presumption is conclusive or irrebuttable, and it is open to the child of such marriage to lead evidence to show that she was brought up by the mother. The same word of the Supreme Court used also. Was brought up by the mother who belonged to the scheduled caste, scheduled tribe. By virtue of being son of a forward class father, he did not have any advantageous start in life, but on the contrary, suffered the deprivation, indignities, humilities, and handicaps. So these are the 4 attributes, Lordship, the vigilance officer have to look into in terms of paragraph 13.5. Deprivation, how she was deprived. Indignities, where she is facing humiliation, humilities and handicap. She is a student of a missionary school. She was all along studied in Cotton College. She has a good background. Her parents are belonging to the creamy layer. So there is no case of deprivation, indignities, humilities, and handicap. Like any other member of the community to which his or her mother belonged. Additionally, that he was also treated a member of the community to which mother belonged, not only by that community, but by the people outside the community. In our case, the whole case is that she was staying with her parents, father and mother, not mother. So this whole principle is not applicable in the case of the writ petitioner. So when she is staying in a happy family with her parents, this benefit in case of being deprived and singly groomed by the mother, that advantage or that benefit is not entitled to the writ petitioner. I'm not going into the creamy layer, non-creamy layer issue. That issue will come later. That issue was also a part of the hearing in the division, before the division bench. The law is very well settled. No OBC can claim benefit if they belong to the creamy layer. The father is a class 1 officer, mother is a class 2 officer. My friend said that master roll worker, that was before 2005. She was a master roll worker. But after her regularization in 2005, she is a gazette level 2 or grade 2 officer in the irrigation department. So by no means, by no stretch of imagination, she can reap benefit of OBC being a creamy layer person. কোনো কাকো ল্যান্ডে করা নাই নাই করা একো কাকো করা নাই রেগুলার নর্মাল ফ্যামিলি So my humble submission would be Lordship, then I am stopping.
You want to make a submission, make it.
Lordship, after that.
No, you want to make a submission.
Yes, so my humble submission at this stage in the review is that Lordship may be pleased to admit, fix it for final hearing. If we succeed, then the writ appeal will get opened. There we will get the opportunity to argue on every point.
My
Lord, before your Lordship dictates the order, my Lord, I will just like to point out 2 documents, my Lord, because the subsequent inquiries, like in the fake DC signature, stop source of about the press release. Similarly, my Lord, I would like to, with your Lordship indulgence, when my client took admission in Cotton College, she simultaneously took admission in the hostel, my Lord, that is the receipt. In the year 2009. And my Lord, in writ appeal 42,
That is for 1 month.
in
fees.
all documents, my Lord, I found this, I could not trace out the other, my Lord, but way back in 2009.
We have issued a
And-
so cause to her. She can always reply with all these materials. to
And my
come.
Lord, in writ appeal 42, filed by the private respondent, Lordship, page 90 to 93, there are certificates issued by the Sarkari Gaonpura. These Sarkari Gaonpura certificates are not referred to by the inquiry officer in the subsequent inquiry, my Lord. Writ appeal 42, page number 90 to 93. And my humble submission before this honorable court is that my certificate was issued in the year 2006. So the situation as was operating prior to 2006 has to be looked into, not whether my father was living with me in the year 2019 or something like that, my Lord. Now, what the other side is trying to project is that now the subsequent development as happened in the year 2009.
What was your father in the year 2006?
Pardon, my Lord.
What was your father in the year 2006?
He was a doctor, my Lord. He was a government servant. Government servant. Para 4 of my writ petition I have stated, my Lord.
Regarding deprivation, I could not go through it, but these are the relevant factors when a deprivation in caste situations. A very good note, but today the time is not sufficient to make the arguments. If Lordship may have a look at it. What are the deprivations? What can be deprivations in caste and religion situations? In appropriate time, I will make submissions on this.
For the assisted by Mr. Tina. Senior government.
Our certificate. এখানে নিয়ে দিব ওটাতে। দুইজনকে দিব লাগে।
Also heard Mr. K. N. Chetri, Planet Senior Council, assisted by Mr. J. N. Patel. J. Patel, and council of the opposite party. For the respondent number. Placed on 19th.
Deeply obliged, Lordship. List on it. Deeply obliged. Our record is again. Also, we have more records also if Lordship wants to have papers.
That will be a part, if we entertain this review petition.
Yes.
Then only, otherwise we're not going on that.
My lord, regarding the citation, that 1969, my senior could not give, my lord. Plain commissioner's case, my lord. Regarding the power. To whom the power is entrusted, he should exercise that power. Otherwise it will be.
Oh, that's a
approved.
very old case.
Yes,
Right.
1969, one
It is
SCC.
in AIR, I think so.
Well, I have the SCC certificate. AI also it is reported. 1969, one SCC. 308. Deeply obliged.
It's okay. Where is Mr. M. Nath? What is item number given? M. Doctor.
38.
Just click it. Pursuant to the order of the court passed earlier on. Mr. M. Dutta, learned counsel for the petitioner. As well as Mr. Z. Paik, standing counsel, Home Department Assam for the state response. Have submitted here written arguments. Already have. Let's just come back for the single bench.
Madam, item number 4.
Mr. Goswami,
I prepared the written submission for it.
Mr. R.B. Goswami, learned counsel for the petitioner. And Mr. M.K. Chaudhary, learned senior counsel, assisted by Mr. M. Kalika, counsel for the restaurant number Oil India Limited, has submitted their written arguments for the respective parties. Order is the.
Obliged, my lord.